Bang the gavel. Aloha mai kako and good morning to everyone, both panelists as well as people who are here for round two, day two of this interesting and contentious docket. Today is the April 29th, 2021 portion of the Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program, in order to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are able to view the meeting via the Zoom webinar platform. For all participants, as I often say, try to say every day, please, I want to stress the importance of speaking slowly, clearly, and directly into your microphone. Please also be aware for all meeting participants that this meeting is being recorded on the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record for this event. If you do not wish to be part of the public record, you should exit the meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. So please note, because of that, occasional disruptions to connectivity may occur for one or more members of the meeting. If that occurs, please let us know and be patient as we try to restore audiovisual signals so we can conduct this business safely during the pandemic. I will note that I closed public testimony on this agenda item at the close of yesterday at 4:30, when all people who had submitted written testimony and been given a chance to testify, as well as all individuals who had raised their hand, had been given at least once the opportunity to testify. To state again what I stated at that time, should the commission choose to determine that the City and County of Honolulu has met their burden and followed the procedures laid out in Hawaii Revised Statutes 205 for bringing this matter before us, we will again open up public testimony when we consider the merits of the City and County's proposal, and any individual property owner will have the chance to contest their desire or lack of desire to have their lands included as IAL. But we won't be accepting more public testimony on the agenda items today. My name is Jonathan Lee K.K. Scheuer. I currently have the honor and pleasure of serving with my fellow commissioners as the chair of the Land Use Commission. Along with me, Commissioner Ed Axon and Don Chang, Arnold Wong, our LUC Executive Officer Daniel Oredenker, our Chief Planner Scott Derrickson, our Clerk Riley Hakoda, our Deputy Attorney General Julie Chena, and our court reporter Jean McManus, as well as our program specialist Natasha Quinones, are all on the island of Oahu. We also have another Oahu Commissioner, Gary Okuda, but he has recused from the docket that remains before us today. Commissioner Nancy Cabral is on Hawaii Island. Commissioner Lee Ohigashi is on the island of Maui, and Commissioner Dan Giovanni, who should be joining us at approximately 9:30, is on the island of Kauai. We currently have 8 seated commissioners of a possible 9. Yesterday, we deferred approval of the minutes because they were not completed from our previous meeting, and that was due to the tremendous amount of fielding of telephone inquiries and other inquiries from members of the public regarding the county's IAL petition. The minutes are not ready today for approval, and we will instead take up approval of the minutes from our previous April meeting at our next meeting, should the minutes be ready. At this time, I want to confirm with our 2 members of the meeting who had to leave early yesterday that they were able to review the Zoom recording of the meeting. Commissioner Wong?
Yes, Chair, I have reviewed it.
Okay. And Commissioner Axon?
Yes, Mr. Chair, I did review the recordings.
Okay, thank you very much. And I'd like to ask Mr. Derrickson or Mr. Hakoda, when there were a number of inquiries in the chat, or in the Q&A rather, about when and how the meeting recording might be posted to our website, could you share that for interested members of the public?
This is Scott Derrickson. We will post a link to the recordings on our website under the city and county IAL matter under our pending petitions within the next couple days.
Great. Thank you so much for that, Scott. Okay. And I think that's it. Our next agenda item is the continued hearing and possible action on the conformance of the City and County of Honolulu's important agricultural lands, or IAL, recommendation to their applicable statutory and procedural requirements. We are here to consider whether or not the City and County of Honolulu recommendations for the designation of important agricultural lands on the island of Oahu complies with the requirements of sections 205.47, 205.48, and 205.49 Hawaii revised statutes, and whether the proposed proper procedural, legal, statutory, and public notice requirements were met in developing the recommendations. The lands recommended for designation have been listed in Appendix H of the City and County of Honolulu's IL petition, which along with meeting materials have been and are available for public review at the LUC's website under the City and County of Honolulu IAL link. I will also note for the record, just to update, that we've later yesterday received additional written testimony, which should be posted to our website from John McCaulson, Simon G. Chong, Karen Wong, Ralph Aona, and Peter Opdahl. With that, where we left off yesterday, again, was the close of public testimony on this matter, and we will now, our order for the day will be to hear from the City and County of Honolulu, and questions from the commissioners for them, hear from the Office of Planning and questions from the commissioners from them, and then commission deliberation and action, if we choose to, regarding the question before us today on the adequacy of the county's compliance with procedural and other requirements of Chapter 205. Parties, would you do appearances and also respond whether or not there's any questions on our procedures for today, starting with the City and County?
Aloha, Chair, Vice Chair, and members of the Commission. Deputy Director Don Apuna on behalf of DPP. Here with me today is Ray Young and Dina Wong. I have no questions regarding process today. Thank you.
Thank you.
Good morning, Commissioners. I'm Allison Kato, Deputy Attorney General for the Office of Planning. Also here with me is Ronnie Funikoshi from the Office of Planning. Thank you. No questions on the.
Okay.
Thank you.
So with that, and I will note there's a question in the Q&A, and I'm sure our staff will respond to it. But yes, we are not accepting additional oral testimony today. If somebody wishes to submit written testimony, they can do so at any time before the close of today's hearing. But we did, after a number of hours of testimony yesterday, close oral testimony on the matters before us. With that, Ms. Apuna, are you ready to proceed with your presentation?
Yes, Chair, I am. I was wondering if I could share my screen. I have a PowerPoint.
Please go ahead.
Excuse me, Chair, this is Jean. I'm getting more feedback or something going on with Ms. Apuna's. There's more talking in the background or something that I'm hearing.
Okay, is this better?
I am also picking up there. It's like we're picking up background noise from your office, Ms. Apuna.
We have really thin walls over here. Just hold on.
She's yelling, "Hey, shut up!"
Okay.
Well, that's the best we can do. That's the best we can do.
Yeah, I'll try to speak loudly if that's.
Okay, it's more that just the background is coming through, just so you know.
Okay.
Please proceed, Ms. Apuna.
Thank you. Let me just try to share my screen. Okay, can you see my screen? Okay.
Yes, we can.
Okay. So thank you for this opportunity to present the city's recommendation of IAL for the city and county of Honolulu. First, we should clarify what it means and does not mean to have one's land designated as IAL. Under the statute, the objective of IAL is to identify and plan for the maintenance of a strategic agricultural land resource base that can support a diversity of ag activities and opportunities that expand ag income and job opportunities and increase ag self-sufficiency. While we are currently focused on the recommendation of IAL for designation that creates this strategic agricultural land resource base, the other major component of IAL is the incentives and protections to be made available to landowners and farmers to enable, support, and perpetuate agriculture on their IAL lands. And because these incentives and protections aren't fully developed yet, we understand how some only see the stick and not the carrot of IAL. The counties and the state are charged with creating incentives and protections that IAL landowners can take advantage of because of their IAL designation. Currently, there is the IAL Qualified Ag Cost Tax Credit, although unfortunately, I understand that credit will sunset at the end of the tax year. From this point, hopefully having completed the recommended mapping portion of the IAL process, the city is committed to continue working with landowners, the community, and appropriate agricultural entities to develop these incentives and protections for IAL landowners to enhance their ability to use their property for agriculture for now and into the future. The county process is important because it takes care of small farmers and landowners who can't afford to spend the time and $60,000 to $100,000 in lawyers' fees to go through the volunteer IAL designation process. I don't believe the LUC has ever seen a small farmer or landowner come in for a voluntary IAL designation. DPP does know farmers that have been waiting for the county process to move forward because they wanted to take advantage of the IAL Qualified Ag Cost Tax Credit. Going back to understanding the designation of IAL, IAL is an overlay to the current state agricultural district classification and the county Ag 1 and Ag 2 zoning, and is similar to the city's community growth boundary, which is a tool to identify and plan for protection or encompassing of land uses. An IAL designation is not a reclassification or rezoning in the conventional or state or county sense. It is not a change from the current state agricultural district classification and county Ag 1 and Ag 2 zoning. Therefore, generally, whatever uses are currently allowed on one's property, which is basically agriculture, will not change and will not be affected by IAL designation. However, HRS 205-45.5 does appear to create relatively greater restrictions on farm dwellings and employee housing on IAL designated lands. HRS 205-45.5 more narrowly defines the use of farm dwellings and employee housing on IAL. Under HRS 205-4.5, the definition of farm dwelling that this commission is familiar with, based on last year's declaratory ruling on short-term rentals used as farm dwellings on the Big Island, requires more generally that the farm dwelling or employee housing be located on and used in connection with the farm, or where agricultural activity provides income to the family occupying the dwelling. Whereas the IAL farm dwelling requires occupancy of farmers and their immediate family members who actively and currently farm on IAL. HRS 205-45.5 also requires that any new farm dwelling and employee housing unit on IAL shall be supported by agricultural plans that are approved by the Department of Agriculture. Currently, ag plans are not required for new farm dwellings on ag classified or zone land. However, this requirement helps to protect against gentlemen's estates and purely residential uses of farm dwellings. The limitation of 5% of the total IAL land area for farm dwellings and all appurtenances may or may not be more restrictive than the city's current requirements. depending on the circumstances. For Ag 1 county zoning, one farm dwelling is permitted within a 5,000 square foot polygon for a minimum 2-acre lot. To be clear, if a landowner is not currently using their land for agricultural use, for example, they're using it for residential use only, they may well be in violation of state and county land use laws, regardless of IL designation. We heard yesterday that farmers want to retire on their land or have multiple generations to continue living on the land, which is reasonable, but the intent and law, even without IL designation, would prohibit purely residential uses unrelated to agriculture. If the intent is to remain on agriculturally classified or zoned land without farming it, ideally, the landowner should reclassify or rezone their land to the more compatible or appropriate classification or zoning. Should an IL landowner decide to reclassify or rezone their property and take it out of its current state and county agricultural zoning, for example, to urban or residential, the proposed reclassification or rezoning would require the LUC or the county to specifically consider certain standards and criteria as outlined under HRS 205-50. This is basically the IL process in reverse to weigh whether the removal from IL would disrupt or fragment agricultural activities in the area, and to consider whether it is reasonable to remove the property from the greater IL strategic agricultural land resource base. The statute also allows for a landowner to petition the commission to remove the IL designation if a sufficient supply of water is no longer available to allow profitable farming on the land due to governmental actions, acts of God, or other causes beyond their control. We would also like to clarify the city's and the commission's role in the IL designation process. The city was tasked with following the county process and IL standards and criteria of HRS 205 to identify and map potential IAL. Our job was to cast a wide net of participants and community members, as well as in the application of the standards and criteria. From there, we tailored the maps based on the county plans, comments of agencies, landowners, interest groups, and representations or position statements of owners whose lands are subject to potential designation. The City Council reviewed, further edited, and transmitted the proposed maps to the Commission. The proposed IAL before you is a recommendation to the Commission, not the final IAL. All that you need to do today, however, is determine whether the city fulfilled the county process as outlined under HRS 205-47 and whether the standards and criteria were properly applied under HRS 205-44. Generally, that's it. There is no need to consider whether the outcome was what you expected, no need to look at the maps or even consider individual parcels or landowners. Just determine whether the city followed the process and the application of the standards and criteria as written in HRS 205. You may not be happy with the result, but focus on whether the city complied with the requirements of the law. What you may realize is that if you are not happy with the results, but the city correctly followed the process and met the requirements, perhaps the process itself has failed. If that is the case, the Commission's recourse is with the process, not the city. Is the county process as provided under statute perfect? No, far from it. Being the first county to come before this commission with a recommendation, we are seeing some of the flaws in the statute. If you remand the project back to the city, it must be based on a failure of the city to meet the standards of the county process of HRS 205. And we ask that you state definitively how we did not meet the standards of HRS 205 so that we and the other counties have a clear path forward. If the commission accepts the city's recommendation of IL, it is the commission's role to proceed to identify and designate IL. At this stage, the commission will not be limited to the city's recommendation, for its record. The commission is instructed under HRS 205-49 to also consider IL declaratory orders, quote, any other relevant information, end quote, and importantly, landowner position statements and representations like those that were made yesterday. The city will have handed off its recommendation, will provide any other relevant information if requested for by the commission, and will defer to the commission in its process to identify and designate IL, including any decision to exclude or include individual parcels. Now moving on to the city's recommendation of IL. The city began the IL process back in 2011. Over $350,000, hundreds of volunteers, and countless hours have been spent on this project. Over the past decade, the project has changed hands among 3 or 4 different project managers under at least 4 different DPP directors. However, we are here today to demonstrate that the city has stayed the course and its recommendation for the designation of IL sufficiently complies with the statutory requirements of HRS Chapter 205, Part 3, including the proper procedural, legal, and public notice requirements. The city's process for the designation of IL can be broken down into 2 basic phases. Phase 1, the preparation of resource maps and weighing of criteria under the Technical Advisory Committee, or TAC. And Phase 2, the community engagement process of various rounds of public meetings, landowner notifications, and public comments on the proposed IL designation. Thereafter, DPP finalized the maps, published an ad in the paper, and transmitted the maps and report to the City Council. The City Council reviewed the maps, held public hearings, and adopted the maps with a few changes and transmitted the recommendation to the LUC. The city's process for the identification of IL meets the county process of HRS 205-47, which has 5 essential requirements. First, they're based on the standards and criteria of HRS 205-45C, that they're in consultation with landowners and appropriate agricultural interest groups and agencies. C, an inclusive process for public involvement, including a series of public meetings throughout the process. D, take reasonable action to notify each landowner of IL affected lands. And E, submit IL maps to the City Council for decision making. So first, HRS 205-47A, which I will talk about a little later. HRS 205-47B. The city's identification of IL was developed in consultation with landowners and appropriate ag interest groups and agencies. The city's Technical Advisory Committee included 25 farmers, ag representatives with expertise and are experienced in the ag industry. The TAC with DPP and its consultants, Helber, Haster, and Fee, met 6 times from 2012, during which they essentially weighed the standards and criteria, developed resource maps and map refinements. While there was only one landowner in the TAC, multiple landowners were also consulted through the various focus groups and community meetings throughout the entire county process. HRS 205-47C, the city's identification of IL, was an inclusive process for public involvement, including a series of public meetings. Following the development of the resource maps and criteria weighting by the TAC, there were 3 focus groups meetings in January through February 2015 for preliminary consultation, and then 3 community meetings throughout the island for further development of the maps. There are also 2 separate 60-day comment periods and a city website featuring IL web-based viewer. HRS 205-47D states that the city shall take reasonable action to notify each landowner of the potential designation of their lands by mail or posted notice on the affected lands to inform them of the potential designation of their lands. On December 29, 2016, the city mailed notices through the U.S. Postal Service to the approximate 1,800 landowners that would be affected by the proposed IL designation, informing them of the upcoming community meeting. On November 8, 2017, the city sent notices for a subsequent community meeting. And on January 10, 2018, the city sent notices for return mail from the prior mail out to addresses based on DPP searches with Budget and Finances, Real Property Division, the DCCA, and other internet searches. These mailouts included explanation of IL and the county process, as well as contact information for further questions. Additionally, DPP issued press releases on March 25th, 2015, April 7th, 2015, January 5th, 2017, and November 13th, 2017, to inform the public of upcoming IAL community meetings. And on October 7th, 2018, DPP published a half-page ad in the Star Advertiser that included the proposed IAL map. The city took reasonable action to notify each landowner of their lands potentially being designated IL by sending multiple mailouts to landowners to meet the standard of HRS 205-47D. On top of that, to further spread the word, the city made multiple press releases and a half-page ad in a newspaper of general circulation. I'd like to note that for a county rezoning, which is an actual change in land use, the city is only required to send out one mail out and one publication. Although many of the testifiers said that they did not receive notice from the city, the majority of them are on the city's mail out list. If there are roughly 100 of 1,800 landowners who say they did not get a mail out, it's about 5%, which is not a substantial percentage. Of the 5%, some may have been lost in the mail or were overlooked by recipients. We don't know, but the city met the, we don't know what happened necessarily, but the city met the standard for HRS 205-47D by taking reasonable action to notify each landowner by mail. Lastly, under HRS 205-44E, the city submitted the proposed IL maps to the City Council for decision-making on August 31st, 2018. In its deliberations, the City Council eliminated 3 parcels. The City Council transmitted Resolution 18-233 to the Commission on September 22nd, 2020. Based on the foregoing, the city has met 4 of the 5 requirements for the county process for the designation of IL. As for the fifth requirement, subsection A, the standards and criteria for the identification of IL. The Commission is familiar with the 8 IL standards and criteria of HRS 205-44C, and that not all 8 need be satisfied. Rather, lands meeting any of the criteria shall be given initial consideration, provided that the designation of IL shall be made by weighing the standards and criteria with each other to meet the constitutional purposes and objectives and policies of IL. The city created a criteria weighting methodology to select the priority criteria used in the city's mapping process. Following initial consultation with the TAC to better define the criteria, TAC members completed a ballot to distribute a total of 100 points across the 8 criteria. The value of the combined score was used to determine the larger group's combined preference. Criteria with more cumulative points received a higher score and were considered to have a greater degree of importance. Criteria with the highest values were identified as priority criteria based on the natural grouping of scores. Among the 3 highest ranked, 4 highest ranked, or 6 highest ranked criteria, the TAC voted to use the 3 highest ranked criteria, which are as follows: Criteria 1, current agricultural production. Criterion 2, soil qualities and growth conditions. And criterion 5, availability of water. After considering the implications of the different ways to apply the criteria, consistent with the objective to be as inclusive as possible, the TAC recommended that land satisfying any one of the 3 highest ranked criteria should qualify for designation as IL. This approach was presented at the first community meeting and carried through to the final map of recommendations. Based on this criteria weighting methodology and the application of the 3 highest ranked criteria, the city's proposed IL satisfies the standards and criteria for identification of HRS Section 205-44C. The city did not visit individual landowners to check for current ag production, soil qualities, availability of water, etc., because data on those criteria were readily available to the city and were put into maps for the TAC focus group and community members to view and analyze. Based on the foregoing, the city has complied with HRS 205-44C in the application of the standards and criteria of IAL. In conclusion, the city believes it has met the standards of HRS Chapter 205, Part 3, and therefore humbly asks the Commission to accept the city's recommendation for IAL. Thank you, and we are available for any questions.
Thank you, Ms. Apuna. Yeah, if you would stop screen sharing, please. Commissioners, questions for the City and County of Honolulu? Who wants to go first? Commissioner Wong.
Okay, Chair. You want me to give other commissioners a chance first? Because after reviewing this and after reviewing the docket, I have like 4 pages of questions.
I have some confidence that all of the commissioners have a great deal of questions for the city and county after yesterday's very long day. So
Okay.
why don't you start and then maybe take a break partway through and give a chance to other commissioners, and we can come back to you for sure.
I just want to say hi to Commissioner Giovanni,
Yes.
Chair.
Welcome, Commissioner Giovanni. Thank you.
Okay, thank you, Chair. Good morning, Ms. Apuna.
Morning, Commissioner.
Okay. Please forgive me if I keep on calling you counselor instead of deputy director. But I'm going to start. Going through this, what year did the report come out again? The DPP is using on its recommendation?
So if you're referring to the city council's submittal, the exact date, it was in 2020, September 22nd, 2020. The city council transmitted the resolution to the LUC.
Okay. So the technical advisory group or committee report, when did that one come out?
I don't think there was.
Hi, this is Dina Wong, DPP. Our final report was published in August 2018, and it includes the appendices on the meetings.
Okay. Chair, do you want to swear in Dina or Raymond just in case?
Yeah, I was just thinking that. Do you swear or affirm the testimony you're about to give is the truth, Dina?
Yes.
Thank you. Please continue.
Thank you. So when was the last technical advisory committee meeting?
I have to look it up, but it's in the testimony. Is it in the testimony?
I
All right,
understand it's under the testimony.
Raymond,
Mr. Young.
are you speaking?
No,
Okay. So my question again, when was the last technical advisory committee meeting? I want to make sure everyone here knows what day it is. If
Okay, if you could just give us a moment to search up that date for you.
Okay.
For 2015.
February 4, 2015.
So the last meeting was is 5 years ago. Is that correct? Approximately?
Yes, well, it's 2021, so right, about 6 years
6
ago.
years. So the report from that technical advisory committee for the basis of your submittal was done approximately 5 to 6 years ago. Is that correct?
The actual report was finalized in August of 2018.
Okay, so that's approximately 3 years ago.
Yes.
Okay. When you sent out the notice to all the landowners of their properties to be designated IAL, I just wanted to make, excuse me?
Can we just go back to clarify the previous question? Was
Sure.
it the last TAC meeting or focus group meeting?
TAC meeting.
Okay, June 19, 2013.
Oh, I apologize. June, what was that reading?
19, 2013.
June 19, 2013.
Okay, so that was 8 years ago then, correct?
Yes.
And so the focus group meeting, that one was a little bit later, is that correct? That was the date you were stating?
Yeah, the 2015 date that I stated earlier was the focus group meeting.
Okay. So all these, your submittal was inclusive of both the focus group and the technical advisory group meetings, correct?
Yes, the final report reflected all of the input provided by the TAC and the focus groups.
Okay, so going to my last question, just wanted to make sure on the record, when did you send out the notice to landowners on their properties that could be designated IALs? What dates again?
Hold on a second, please.
Right here. So, it was December 2016.
December 2016.
Yeah, it was December 29th, 2016, November 8th, 2017, and January 10th, 2018.
So that was approximately 2.5 to 3 years ago, correct?
Yes.
Okay. And so there was nothing in the future, like some of the public witnesses stated that they just bought their property last year or anything. There was no way to touch them at all, correct?
After the county submittal to the city council, it was in their hands. So if people wanted to testify that they wanted to be in or out, that was their chance at city council. So they did not come to the DPP.
Okay, so sorry, when was the city council meeting on this?
It was at the Zoning and Housing Committee on April 25, 2019. And then full council at June 5th, 2019.
They had another meeting on May 8th.
Oh, I'm sorry, also May 8th, 2019.
For the record, if Mr. Young is going to continue to speak, I'm going to swear you in too. So
Okay,
you swear from the testimony you are about to give, Mr. Young, is the truth.
I do.
Thank you. Please also, for the court reporter, identify yourself before speaking since we can hear you.
Okay.
Thank you. Please continue, Commissioner Wong.
Thank you, Chair. So as a result of your notices that was sent out approximately 3 years ago, how many comments did you receive from the public about the notice?
I don't recall receiving it.
I'm sorry, Commissioner, was your question after we sent it to council or before?
Before?
Okay.
Yeah.
We had
93.
approximately 93.
Okay. And how many landowners did you send out to? How many letters did you send out apart or are impacted by this IAL?
I believe it was approximately 1,800.
So if my rough math is correct, it's approximately 5% that you got returned some comments, approximate.
Yes, that would be correct.
Okay. So the other question of that 5%, 4 to 5%, were there any objections on these comments of their designation?
Right there. This is Raymond Young. In our testimony, we detail all these different steps. So of the 74 landowners that responded with written comments, 67 expressed dissatisfaction. And actually, this is on page 8 of our testimony.
Okay, I understand about your testimony. I reviewed your testimony, but for those people that didn't have the time or effort to review your testimony, especially the general public, I would like to state it on the record. That's why I'm asking these questions, Mr. Young.
Sure, understood.
So again, the 67 that said dissatisfaction, did you follow up?
What do you mean followed up?
Like saying, let's say I said, I'm dissatisfied. Did you follow up and say, okay, so let's talk about this, let's try work it out, or let's say, this is the process to say I object to get myself out of this? Did you send anything after that?
Yes, we have individual letters going out to each of these landowners who commented. And the letter basically says, we'll take your comments into consideration and then let them know of the final results before we send to council.
And how many letters did you send out before it was sent to council?
I haven't had a chance to go through all those letters, so I am under the impression that everyone who sent in a written comment, received an individual reply written in a letter from the director.
Saying yes, they're taken out. Is that what you're trying to say?
No, that we will take their comments into consideration and let them know of the final decision.
Okay, so that's pretty much saying we'll talk to you later after everything's done, instead of saying we're going to do something about it. And because I'm trying to get into my mind, could DPP at that point in time with the director say, okay, let's take these people out because they're too small or they're not an agricultural use? Bless you.
Thank you. Sorry.
If you're asking whether or not the director took each of these comments into consideration before preparing the final map, yes.
Okay, but that seems like all 67 still went to the full council, and even though they had objections, nothing was done about it.
That is incorrect. We actually took out quite a bit before sending the final map to full council. And after, or at the time we sent the final map to the full council, we did send out postcards to all the people who sent in written comments, telling them to basically look at our online map to determine whether or not they are still in the proposed IAL map, and that they can further participate in the process by contacting city council.
Okay, so do you have a number of how many people you took out of the final map that went before it went to council?
Okay, that's going to take me a moment. I can go through the report, which indicates in a matrix how many were actually removed, how many were added in, and all the different decisions that the director had made. Hold on a minute.
Hello, this is Dina Wong. In our report of August 2018, we removed 45 from IAL and 7 were added in by landowner's request.
Oh, that's interesting. Okay, thank you. Of the notices that you sent out, how many of them was returned mail because of no addresses, or they don't live here, or they don't know where to go?
This is Raymond Young. So there was 2 series of notices. The 2016 notice that we sent out indicating to the landowners, this is the first draft of our proposed map. We don't have at this moment a record of how many were returned. However, for the 2017 mail out of notices indicating this is the revised draft, we have about 125 return envelopes for which we research. Perhaps they have a different address online, the tax office records and so forth, and those who signed up for previous meetings. We revised their addresses and sent out again. So basically about 125 for the 2017 notice.
So I got a question for you. You were here yesterday, you heard all of the public witnesses, and a lot of them, I would say a good majority of them said they weren't notified. How would you respond to that? The
process doesn't require documentation that they were receiving or they received the notice. So we did a regular USPS mail out, standard letter first class, and based on a list that was created in 2016 and 2017. And I would say 90% of those who said they were not notified were on our 2016 list. And I can double check and reply to you back on a 2017 list.
Okay. At the same time, you know that notification letter that you submitted, is it a part of your exhibits? Anywhere in your exhibits?
I don't believe so.
Could you send a copy to LUC, because I would like to see what it said, and if possible, also the postcard or anything you sent out to the public?
Okay, will do.
Thank you. You know, I still have a concerns with some of the public witnesses that said, hey, you know, I bought this land in 2017, 2018. I didn't know anything about it. Was there any way to update this, or, you know, just to say, hey, you know, you are going to be an IAL, or it's going to be in the process?
I appreciate where your question is coming from. We, as the City Department of Planning, was tasked with doing this mapping and being very inclusive with the community and all the landowners involved. We did the multiple notices, multiple public meetings, and created the TAC just like what Chapter 205 IAL law required. And when we completed this task, it was all sent off to City Council, the report, the maps, and the list of TMKs that we were proposing to be candidate IAL. After it gone to council, we believe it was the council, if they believe that they needed to do an future notices or at their deliberation process require another notice to be sent out, they didn't ask us to do that. They proceeded through pretty much their own process, which is publishing their agendas and notices, and that's pretty much similar to all other ordinances or resolutions that they process through. And that was sent to the LUC back in, I think it was 2019 with the resolution 18-233. So we did not do any, bottom line is there was no additional notices after the recommendation was sent to City Council as far as how we did individual mail outs to affected landowners.
Commissioner Wong,
have-
when do you think you'll hit a breaking point?
Give me 3 more questions, then I'm going to give return the chair to you,
Okay.
back to the floor back to you, sir.
Thank you.
Did you take into account, or you know, where the Land Use Commission does a lot of renewable energy, solar farms, wind farms, etc., and they're on ag land. Did you take it into account on those, like solar farms that are on ag land?
Are you referring to the selection process?
Yes. Or did you contact those owners about that?
That I was not familiar with, but in the 3 criteria, the main 3 criteria that the TAC had selected, one of them was ag use. So if there was a PV farm on the land, it did not preclude the availability of that farmlands to be made available to compatible ag, which is in accordance with the statute. So I imagine, yes, we did.
So I guess my last question, following up on this issue about solar farms or wind farms, were any of the energy producers on the TAC?
Give me a moment and let me check.
Okay.
Commissioner Wong, this
Yes.
is Dawn and Puna. I just, under the standards and criteria of 205-44, the 8 criteria, I don't believe that there is any criteria that speaks to energy production.
Okay. Yeah, I just was wondering, just because, as you know, Ms. Apuna, that we did solar farms on ag land, and I just was wondering if they were even part of this conversation. So you can answer, Mr. Whoever on DPP, you can answer that later. I'm going to return the floor back to the chair. Thank you, DPP. Thank you, Chair.
Thank you. Thank you very much, Commissioner Wong, and I look forward to coming back to you as well. Commissioner Chang.
Thank you very much, Mr. Chair. And thank you, Ms. Apuna. It's very nice to see you on the other side of the table. I will tell you, reading the city's report, I had one perspective, and then listening to the public testimony yesterday really made me think long and hard. So I'm going to ask you a series of questions, and hoping that you can help clarify for me. It is based upon my reading of the statute as well as your own testimony. The role of the county is to prepare the maps and make recommendations for IAL designation. Is that correct?
Yes, that's correct.
And then ultimately, it is the Land Use Commission that makes the final determination on those recommendations on the final IAL maps. Is that correct?
Yes, that's correct.
Okay. And I wanted to confirm, because I don't see anything in the statute or the rules, but do you know, again, any statute, rule, or law that requires each county to designate or recommend a percentage of ag land that should be an IAL?
No, I don't believe there is such a requirement.
I couldn't find any either. Looking through your I guess it's your petition. Is it your petition? Your recommendations, looking to the recommendations. If you can confirm these facts for me, so I'm trying to calculate the amount of acreage we're talking about, that there's approximately 386,000 acres on the island of Oahu. Is that correct?
Yes, I believe that's correct.
And out of those 386,000, 128,000 acres is designated agricultural district.
Yes, that's correct.
Out of that 128,000, approximately 54,145 acres has been voluntarily designated IAL by the private landowners. Is that correct?
I'm not exactly sure. I don't know if Ray or Dina can chime in on that.
This is Dina Wong. About 56,145 acres were excluded. So that included, as you mentioned, landowner initiated process, as well as land owned by the state of Hawaii or by the federal government.
Okay, I was just trying to calculate. I'm not too sure where I got the 54,000, but I could have read the numbers wrong. Okay, nonetheless, we're looking at approximately 56,000 acres that, well, I'm trying to determine what's the total acreage in IAL. So the city, I'm looking for currently the private landowners that have voluntarily designated IAL. Let's just agree, about 55,000 acres. Would that be approximately correct?
We had recommended in the resolution 41,407 acres as IAL. So that did not include the voluntary designation ones, which I don't have a number on that. If you just give us a minute.
Yeah, because I am trying to calculate the total number of acres that are being proposed for IAL. So one, I'm looking at the currently the private landowner land that's been designated, as well as the city's proposed recommendation for IL, and I have 45,428 acres the city is proposing.
I don't have a current figure readily available, but as of February 2019, 14,094 acres were designated IAL through the landowner initiated process. And that included Castle and Cook, Kamehameha Schools, Monsanto, Hartung Brothers, Kualoa Ranch, Robinson, Kunia, and Malai Kahana, which at that time was still pending before the LUC.
Okay, because I am reading your written recommendation that's in the record. And I'm reading through page 2, where it says, of the 128,000 acres, approximately 56,145 acres were excluded from the study areas ineligible. That included lands currently designated as IAL through landowner initiated process, lands owned by the state, and lands owned or in the process of being acquired by the federal government. So is, okay, and Dina or the city, you, out of that 56,000, can you tell me, are you telling me, well, let me ask you this. So could you provide me the number of acreage that is currently designated IAL by the private landowners? And
The number I have, which is not as of today, but was February 2019, was the 14,094 acres.
14th, okay, all right. Okay, I'm gonna take your word for it. So February, 14,094 acres.
Yes.
Okay, and my understanding is that the city, are you currently recommending 45,428 acres?
Our errata sheet corrected that to 41,407 acres.
Okay. And so would I be correct if I'm adding those two, so approximately 55,000 acres is potentially IAL. Would you agree? Is that about that much? Okay. And that would be, and currently there's 120,000 that's ag, so that would be less than 50% of the ag designated lands would be potentially be an IAL. You would agree? My math is.
I'm sorry, Commissioner, can you repeat your numbers that you're adding?
You gave me 14,094 for the private landowners and approximately 41,000 that the city is recommending.
Yes.
So potentially 55,000 acres is potentially an IAL.
Yes, but the 14,094 is already IAL.
Right. So I'm just trying to get the total potential acreage in IAL. I don't want to belabor this point.
Yes, that is correct. If you add those two figures together.
Okay. All right. And again, that would be less than, we're probably looking at about 40% of the ag land potentially could be an IAL. Okay, let me go on to the next question. Now, Ms. Apuna, you know, in your presentation, you talked about the objectives for IAL, which is, you know, the strategic, kind of a strategic foundation to promote strategic agricultural land resource base. So could you explain that how does putting lands that exceed 20% slope is consistent with a strategic agricultural base?
So I think it's part of the creating contiguous plots of land, contiguous areas of agricultural land. So a lot of times, the topography, we'd rather keep everything intact rather than slicing out areas. And from what I understand, based on prior declaratory orders in IL back on Hawaii and here on Oahu, that there were even steeper slopes that were included within IL. So I think at Kualoa Ranch, there were some 25% or greater slopes. And on Kauai for the Robinson IL, it might have been 70% or more. And I recall we saw some goats or cows on the sides of the mountain. But yeah, I think it's keeping these lands fully part and contiguous and inclusive, and ranching can be performed on these slopes.
And I'm not making a judgment whether your analysis is right or wrong, but I'm just trying to understand how these particular considerations further your strategic agricultural land resource base. Okay, so one, these extreme slopes, your consideration was because it was contiguous to existing land and that there could be possible ranching also conducted on these parcels. Could you explain how the small parcels that are less than 1 acre in size supports your strategic agricultural land resource?
I think part of that, it's similar to the slopes that we didn't necessarily, if they were within a larger area of agriculture, we didn't want to just pluck it out and have these little, donuts or circles in the middle. I'd also defer to Ray and Dina if they wanted to expand more on the smaller parcels that were selected.
Yes, this is Dina Wong. So as Deputy Director said, we didn't want to have like that hole in a area or a sea of IL potential lands, but also if those smaller areas were right adjacent to that larger area, we did include it in the recommended parcels.
And these determinations were not based upon a site visit, but based upon existing maps. Is that correct?
Oh, I think you're muted, Dina.
Sorry, that is correct. Site visits to each parcel were not made, but the criterias were, it was a resource-based decision-making process. So using the various databases and layers in GIS.
So, because we heard yesterday from some of the landowners that many of their lands are currently just in residential use. There's no agriculture going on them. Some of them are less than an acre and there's no agriculture. So my understanding is the city relied upon those, your database, but did not do any specific ground truthing of these particular parcels to determine whether they were in existing ag.
Yes, that is correct. But the parcel had to meet only one of the 3 criteria. So even if there was no agriculture occurring on the site, if there was water availability or good quality soils, then it would meet the criteria for recommending it as potential IAL.
Because I am also trying to understand, given the overall objective of IAL that the city used, the strategic agricultural land resource, that you have these criteria, but there's really no confirmation that the actual use of the land would further your strategic agricultural land resource base. And so I'm trying to understand that your decisions that affected many of these private landowners, while it may show up on your maps or may show up in your database, is really not, or maybe you can explain to me, how does it support your strategic agricultural land resource base? If the reality is not consistent with your databases.
I think we're looking at it more in terms of, the long-term goals of IL. So although the current landowner may not be doing agricultural activities on their site, if there is water and the soil quality is good, there could be potential for such activity in the future. And with the IL designation, future landowners could be eligible for incentives, which would all go towards helping to further our agricultural goals, island-wide.
And I appreciate that, but but what we heard from many of the commenters yesterday was that some of these lands have been in their hands for generations, and they intend to keep them in generations. So there's not an intention to necessarily deviate from some of their existing uses. Did you take any of those kinds of information into consideration?
No, the length of ownership of each parcel was not considered.
Okay.
Commissioner Chang, I know that there's do we want to take a break? Or you want to keep going or
Yeah, no,
come back?
if you'd like to take a break, I know we've been going on for almost an hour now.
A little bit over, and
we can always go on to another commission.
okay. I just want to give everybody a chance
Sure.
to, and also give every commissioner a chance to ask every question they have. So it's 10:15. I think we should take a break till 10:25, reconvene. At that time, I'll call on Commissioner Giovanni and Axon to ask questions. And then we'll go back to other commissioners, as well as Commissioner Cabral. Okay. 10-minute recess till 10:25. Okay. 10:25, we're going back on the record. Before I hand it over to Commissioner Giovanni and then Commissioner Axon for questions, for any members of the audience who are attending who perhaps did not attend yesterday's hearing, I'll just repeat a few things that I tried to share yesterday. First of all, the 8 members of the commission, 7 whom are sitting on this docket, are all volunteers. We are not paid to be here. We serve as volunteers. We're appointed by the governor, confirmed by the state senate, serve up to 4-year terms, and up to 2 of them. And we do so just because we believe it's our way to help Hawaii implement its state land use law. We do the best that we can. We work with the advice of counsel and a very small 5 members, but very dedicated staff. We certainly appreciate that many of the people in the public are taking their time off from work and other duties to be with this hearing today. And we hope that our questioning of the city and county will get to some of the questions that you guys raised yesterday. With that, I will hand it over. Commissioner Giovanni, you had questions for the city, followed by Commissioner Axon.
Thank you, Chair. I just want to be certain Commissioner Chang was finished with her questions.
Thank you, Commissioner Giovanni. I'm not, but please go ahead. Well, there will be ample time for all of us to ask all our questions.
Okay, fine.
Thank you.
Ms. Apuna, great to see you again before this commission.
Good to see you, sir.
Which I could see you in person, of course. Let me apologize for missing a portion of your presentation this morning, but let me assure you that I have also pre-read and reviewed all of the information that the city and county has put on record in this matter. So I'm kind of up to speed, but I might have missed a couple parts. So I only have questions at this time in two areas. The first is about the criteria that was by the TAC. Do I understand correctly that if any one of the three priority criteria are met, that qualifies a parcel for IAL designation?
Yes, that's correct. We try to be as inclusive as possible to give you the broadest range of IAL.
So could you explain to me the logic behind that, or at least as you understand it, how a parcel that has no water or that is covered with lava rock and has no soil could be considered for agricultural purposes?
So I think based on the TAC, they're the experts in this case. They looked at the criteria carefully, and they first defined it more to understand based on what their practices, what they thought would be necessary for agriculture, and again to cast the widest net possible. So I don't think we're saying that you can definitely grow agriculture at this moment, but at least one of those criteria is the building block. And when you get the incentives involved and the different things that can help farmers to improve their land to grow agriculture, that leads us on our way to this strategic land source space.
Is there any backup information that is not on record yet in this docket that better explains the tax rationale for specifically how they applied the criteria in order to be more inclusive, as you say?
I think there's some information in the minutes of some of the TAC meetings that's part of the record. I'll defer to Ray and Dina if they have further explanation or can explain to you further.
So Dina or Ray, do you have anything to add at this time? I will review the minutes.
Can you restate the question? I'm sorry, I missed it.
I'm trying to understand the rationale that the TAC applied to come up with this inclusive approach, that if any one of the priority criteria are satisfied, that does qualify the land as IAL.
Well, essentially, the TAC and the way the statute is read is to be as most inclusive as possible. So rather than having a parcel meet all three, it made sense under that provision to allow any criteria of the top three, as long as it's touched, would be considered for IAL.
So I understand that to be the case as you've presented it. I have to admit, it doesn't make a lot of sense to me. That's why I want to research it in a little more depth. And I'm looking for the minutes of the TAC meeting in which they might have explored this idea in more detail. And I'm hoping that that might be on the record in this matter before.
Yes, it is on the record. This is Dina Wong. It is on the record. In the August 2018 report, there are appendices. And Appendix B has the Technical Advisory Committee meeting notes. And Appendix C has focus group meeting notes. So perhaps within those detailed notes, there may be more on how they came up with those three criteria.
Yeah, that would be helpful. Is that August 28th, what year?
The report that we submitted to council was August 2018.
Well, August 2018. Okay, got it. Okay, that's good. I want to move on in terms of process. I have the sense that the large landowners are fairly well positioned and know how to take advantage of opportunities to participate in this process that's gone on for about 5 years to seek that their land either be qualified or not qualified as IAL. I'm very concerned, however, that the small landowners may not be so well positioned to do so. So my question is, and I think this goes to you, Ms. Apuna, can you describe the process by which small landowners could opt in if so incentivized, or opt out if so incentivized of the IAL designation process?
So that's exactly what this county process has allowed. You know, it rather than paying the big bucks to the lawyers to come in for the voluntary designation, the county process, we're trying to, again, be as inclusive as possible, hoping to get all the small farmers in there. And if they weren't part of that, they always had the option to come to us and say that they were interested in IL designation, or to opt out, which was also considered. So this allows them to have the county do it for them and get their IL designation without having to, you know, individually take the time and the money and resources to go before the commission.
So
Oh, I'm sorry, this is Dina Wong. I just want to add to what Deputy Director stated, and also to correct my response earlier. I think the question from one of the other commissioners was how many landowners requested to be excluded or opted out of IAL. And the correct number, and it's documented in Appendix E of the report, is we had 75 requests come in from landowners requesting to be excluded. And out of those 75, 44 of their parcels, and some of them have more than one parcel, these are just the landowners, either their property was removed entirely or portions were removed, and 30 were retained in.
So I'm interested in process, and that's very helpful, Ms. Young. Can you describe the process by which, and just take a for instance, not for any one of these small landowners, if they, how would they proceed? I'm assuming that they would be notified and somehow alerted and somehow, and then given an opportunity to request to be opted out or to be exempted. Could you explain that in a little more detail as you understand it?
Process of opting in or out.
So I think it's part of this whole process, right? We put out different press releases and other notifications to just generally, right? The press releases generally to the community that we're going through this process. And so if they're interested, they could come to the community meetings. We wanted to make them aware generally. And then the mail outs were to the specific potential owners, the potential farmers that were interested. But I think it's a lot of we had press releases and other notifications that went out to the full community so that they were aware that this whole process was available. And so at that time, they could let us know if they were or were not in the first maps considered for designation. They could just call our office and we would take their information and consider them for the IL designation.
Is it fair to say, Ms. Apuna, that they didn't have a clear option in or out? They had the option to request an exemption or not. Is that right?
I mean, I think it goes both ways. So we're trying to capture as much as we can, but we might have missed, for one reason or another, they might have been outside of the designation, the proposed designation, so they could opt in, they could opt out. I don't think it's necessarily weighted in either as an exemption.
My question is a little different. Is the Who has the authority in or out? Is it the county or is it the landowner?
My
Okay.
oh, sorry, this is Dina. My understanding is the landowner requested to the department if they wanted to be excluded. And we looked at their properties and at the criteria, and basically, to make it a fair process, we really looked to the criteria. And so even if they wanted to be out and they met some of their criteria, their property was retained in IAL.
Okay, so they did not have the option to opt out. They had the option to request to opt out, and the county had the final say in whether they were in and out or out. Is that correct?
Well, they had the option to request, and the county, we're just recommending potential IAL. So it's not a definitive decision yet.
Fair enough, understood. One of the gaps that seems to have occurred in the process to me had to do with land that was in transition of ownership during this last 5-year period in which this process has gone forth, in which owners of land that made their land for sale were not obligated to, even if they knew about the IAL process, to inform prospective buyers about it. And prospective buyers were not informed. There was no disclosure of this IAL process to new landowners. So they were acquiring land, and then because they were not recognized as a landowner when the process started back in 2016, comes a big surprise in 2019 or 2020 when it comes forth. Would you agree that this is a potential gap in terms of the process and just in terms of disclosing and informing owners or prospective owners about this process?
So it might be a gap, but I think that, this is not a final decision what the county is putting forth. This is just the recommendation. So even with any type of due diligence that is on the buyers, that's their burden, right? And they're going to look at a property. You'll find zoning, the current zoning, but you won't find what is, prospective or what's in the works necessarily when you do that type of due diligence. So I don't think it's any different than any other type of purchase of property. Nothing is finalized at this point. So as far as the timing, it'd probably be a lot better if we could have done it, more swiftly. But I don't think that, this designation has not been made yet. So I don't think they necessarily were entitled to some type of notification or that property was already designated as IL.
I agree with your statement of conditions or that we currently live by, but would you agree or disagree that it would be a good idea for sale of agricultural lands, parcels in Hawaii, that there be some form of a disclosure that the land may be subject to IAL designation?
I think it would be helpful, but there's nothing in the statute that would require us to provide that type of.
Yeah, I agree with that. But it would be helpful in that a prospective purchaser of a land it would trigger their due diligence, where today there's nothing that triggers
it. Right. Yeah.
Okay. Chair, that's all the questions I have at this time. Thank you.
Thank you very much, Commissioner Giovanni. I'm next going to call on Commissioner Axon, followed by Commissioner Ohigashi.
Thank you, Mr. Chair. Good morning, Ms. Apuna, Dina, and Raymond. I really appreciate the time and effort done by the city on this subject. I know so many years, so many time and effort spent, not only within the department, but community organizations. I just have some follow-up questions based on Commissioner Wong and Commissioner Giovanni's questions. I know you probably covered these, but probably kind of missed it or didn't understand. So forgive me if I kind of repeat some of those. First of all, I heard that you folks sent out at least 1,800 notices to these landowners. And out of those 1,800 that was sent, how many was returned percent wise?
Approximately 130 were returned.
And then I understand that, out of those 130 that was returned, you folks sent out another notice to these people. With that, how many came back that was undeliverable or,
2 were returned.
So it's safe to say that everybody received those notices for the exception of these 2 that the city cannot find those people.
I think it's inevitable that there were some that could not be delivered, and we made that extra effort to run that ad in the advertiser to, ensure that folks had an opportunity to know about this. So that was just an extra step that we took that, to ensure that we met the statute.
Yeah, I understand. I'm just trying to, so I'm just kind of assuming that if the letter didn't, come back, that means the landowner received the notice.
It was sent by regular mail, so there is no absolute
There's no return.
certainty they were received, but if it didn't come back, we assume it was delivered. Whether the owner actually looked at it is, we can't really say that for sure.
I understand. And then out of those 1,800, 5% you said came back with a comments, and majority of them were dissatisfied or object. Did I hear that correctly? 5% came back with a comment.
No, I think so the 5%, I think we were just kind of estimating based on some of the feedback we're getting for this commission, for this, this hearing. Maybe about 100 that said they weren't notified. And so based on the 1,800 total, about 5% said that they didn't get notice.
And out of those that, let's say 5% with the comments and that they were satisfied, you were saying that I believe 6, 7 were taken out from that list from the IAL 45 removed or something. That's what I heard. And 7 were added.
Out of the public comments that we got from landowners, 75, we had 75 requests, and 45 of their properties were removed either entirely or portions of.
Yeah, okay, thank you. What are the criteria used to remove this 45 land? I know you have a three, criteria for y'all, but I just want to kind of get some idea what prompted the city to remove these properties.
We really just looked at those three criteria, but we also looked too on context to see if they were part of a larger critical mass.
Yeah.
And also the,
Oh, excuse me.
sorry, this is Raymond. And also, a lot of them were in the country zoning, and I think that was most of them that were removed. Country zoning allows both residential use and agriculture use. So it didn't make sense to us to include, because we couldn't require agriculture use if the zoning allowed residential use.
I see. So in other words, the city basically reviewed uh, each properties and come out with not only based on the criteria or some other reason was taken into consideration, just like what you said.
That is correct. In fact, when we did the removal of the country district lots, and not all of them were removed, even though they were zone country, we took, for example, up in Pupukia Heights, essentially the whole mountain of small 1 acre, even though they did not request to be removed.
So if I heard it right, there was a 2 acres minimum to be included, to be designated ILA.
I think one of the size cutoffs was at 1 acre, I believe.
Oh, I'm,
1 acre.
um,
I thought it was 2 acres. I heard earlier 2 acres. That's the reason why I'm trying to kind of verify all those numbers.
Parcels that had 5% or less of their land area in IAL were removed, and parcels less than an acre. But there were, as we mentioned earlier, some exceptions made if doing so would create that hole in a sea of IAL.
I'm just trying to kind of verify between the 2 acres and the 1 acre that I'm hearing now, because earlier I heard 2 acres, but so it is 1 acre. So any property that less than 1 acre is not going to be included, because some testifiers yesterday, they have less than 1 acre, or a little bit over 1 acre, and that's the reason why I'm kind of trying to figure out, are those landowners just being alarmed for nothing. I guess okay, 2 acres or 1 acre. That's what I'm trying.
Yeah, I believe it is 1 acre. I think the reference to 2 acres that you are referring to is from a comment letter from the Department of Ag, if I'm not mistaken. And when I asked DOA staff about that, where did they get the 2 acres from? It was because the minimum ag lot size is 2 acres. And in my conversations with various people that was forwarded to me from the LUC staff, I found out that there are some lots as small as 6,000 square feet, which is pretty much fully occupied by residential uses that were also included. And personally, I don't have any objections removing those, because there's no way on 6,000 square feet you can have a reasonable farming operation.
So you can see my confusion, and if I'm confused, I'm pretty sure some of the landowners are pretty much confused too, as evident as yesterday's testimonies. I also understand that there are, no matter what we do, no matter what how many notice we send, there is gonna be a portion of those people that gonna say they didn't receive it, or They just did it, not paying attention. I send out all those notices every time, 5,000 notices, and most of them come back later on when we making final decision and say, oh, we didn't uh, s- receive it. As a matter of fact, we have documentation that they receive it. So that question I have, I don't know if you're privileged to disclose. You have this technical advisor committee organizations. Are you privileged to tell us who are these organizations? I'm looking for organizations that are membership based that could have helped spread the word to their members. Because I know you have a landowner, you have different organizations on the tax list.
Yes, we can share that list with you, or if in fact you want to know it now, I can read it off to you. I have it up on my screen.
Yeah, just a quick one. So because I believe that they also responsible to let people know what's going on if there are membership based.
Yes, okay. Let me go through the list. There are about 20, maybe 23. And in the phase 2 TAC members, we have David Arakawa from the Land Use Research Foundation, Robert Cherry
It's a big
from,
landowners, yeah.
yeah, they represent the major landowners. We have Robert Cherry from Flying R Livestock Company, Ruby Edwards or Rodney Funikoshi from the Office of Planning, Alan Gottlieb from Hawaii Livestock Farmers Coalition, Shinho from Ho Farms, Kenneth Kamiya from Kamiya Gold, Inc., Dr. Po Young Lai, the city's agricultural liaison, Daniel Nellis from Dole Foods Company, Hawaii, Dean Okimoto from Nalo Farms, Mark Phillipson from Syngenta Seeds, Charles Repoon from Waiholi Poi Factory, Anthony Rose from the U.S. Conservation Soil Survey, Leon Sollenberger from Agricultural Enterprises, Ashley Stokes from the UH College of Tropical Ag, Alan Takemoto from Monsanto, Mark Takemoto from Pioneer Hybrid, William Tam from Commission on Water Resource Management, Department of Land and Natural Resources, Barry Usagawa from the Board of Water Supply, Stephanie Whalen from Hawaii Ag Research Center, Earl Yamamoto from the State Department of Ag, and there is a Larry Yamamoto. I'm not sure what the representation there is. Could be a citizen with no affiliation. In the phase 1 members, we have a listing of 2, but I'm sure it was pretty much the same people, Dwayne Okamoto and then Alenka Remek from the Mayor's Economic Development Office.
Out of those organizations or individuals that you mentioned, any one of them would you say represents small landowners?
Well, the big one is David Arakawa from
I'm
LURF.
not talking about, I know he represents big landowners, but I'm kind of trying to figure out the small landowners.
My impression is the smaller farms like Robert Cherry, Shinho from Ho Farms, Kamiya Gold. These are people that was on the TAC that do represent the smaller farm operations.
Yeah, I'm familiar with them. Uh, the other question I have, follow up on Commissioner Giovanni's question about the ownership. I understand that, there is no requirement by for this for the county to disclose to any landowner. But I believe, I don't know, I might be wrong, that whoever is the seller or real estate agent are subjected by law to disclose those information. So I'm just trying to kind of see where, I know Commissioner Giovanni's, question, and I was kind of thinking that how did this thing happen? That, an individual, a person buying a property and didn't know what the, requirements for their land. So you can say that there is a crack on the process or whatever, but that's a really real concern, that land changes hand without any proper disclosures. Maybe that's something that we need to look at, uh, and how we can uh, correct the mistake. One last question I have, or I'm trying to kind of figure out, you know, uh, a chance for, let us say, land use commission, agreed, approved the recommendation by the the city and county. Then whose really final decision, whether is it the city or land use commission, to make those final decision, uh, uh, designating ILA. I'm trying to figure out if the maps that was recommended by the city, is that it, or land use commission has the chance to look at all those properties, and landowners still have a chance to petition land use commission to, in other words, another chance they have to voice their objection. So I don't know, maybe, Ms. Apuna, you have any insight on that?
Yes, Commissioner Axon. So you're correct. This is not the city's decision to make under the statute. It is the commission, your decision. And you don't have to take our recommendation wholesale. You can eliminate certain parcels. You can add to it. You can, I think you do have the authority to look at properties individually, to look at certain objections individually, and to weigh each one and say whether you want to exclude those parcels or not. So that the ball is in your court, and you can do what you want with our recommendation. And I think if you do accept our recommendation, our job would be done. It would be up to you and the rest of the commissioners to further refine the maps as you feel fit.
Thanks for the clarification. I just want to kind of, assure some of those people that, testified yesterday, or those people that couldn't testify, but there are concerns, that they have another chance to, voice objection. This is not a final, thing for them.
Absolutely. Yeah, I think that is, I mean, I'm sure your AG will advise you how you will proceed, but that, I believe, is within your authority, and the city would not necessarily weigh in on what you will do with those parcels.
Understood. Thank you for the clarification. Mr. Chair, that's all I have.
Thank you, Commissioner Axon. And Commissioner Ohigashi, before the break, I indicated I would allow Commissioner Cabral to speak after Commissioner Axon. So when you raised your hand, I got distracted. I would like to have Commissioner Cabral ask questions, then Commissioner Ohigashi.
Thank you. I could have waited, but I'm a little more hot and bothered now, so. And Ms. Apuna, I know we previously saw you on the big or small screen as this may be under wearing a different hat. So how long have you been in your current position and responsible for this city and county problem?
Feels like 3 decades, but maybe 3 months, a little more than 3 months.
Okay, well then, don't take this personal since this has been going on for so many years. Okay, I read everything and then of course, hearing things and it's hard because there's so many numbers. At one point I heard there's approximately 55,000 lots that were put into IAL that were volunteered in by private landowners. And then I heard some other numbers, but give or take 10,000 acres at this point with big landowners, what the heck, right? So anyway, we've got a lot of land in there. Is there a requirement by the state or county and city and county or something that you, the county, city and county are required to have a certain number of acres in there? And is that why you're going after these smaller parcels? I mean, what is the motivation that's taken this much time and effort and money from the city and county to go after small landowners?
So there is no minimum requirement or percentage of acreage that we're supposed to propose. I think, again, based on the criteria that we've narrowed down to, we're trying to cast the widest net so that we can get as much IL designated, but we aren't necessarily looking at individual parcels. We're looking at the basic criteria of land that would qualify. As far as how long it's taken, you know, it's a lot of work, and I think we are what I've learned since I've been here is there's a lot of work to be done on a daily basis. So these projects kind of take a while, but the whole process to have that many focus group meetings, TAC meetings, and community meetings, it's quite a process that does become drawn out. So I do think that that's part of the reason, as well as financial resources to get consultants, that's why it has taken some time to put this before the commission.
I can appreciate that, but I could attack that heavily since I'm in private business and do a whole lot more than that on a weekly basis. So I am can't begin to tell you how much I'm almost feeling personalized with this. Okay, I am terrified now. I have agricultural land on the Big Island, and so now I better pay attention to all the mail I get now, because even though it may appear to be junk mail, particularly if it's not personalized to me or appear to be personalized with my name and TMK number. So I very much appreciate that we have asked to see a copy of these, apparently over a long time period, but actually very few mail outs that went out to the individual lot owners and landowners. So again, with the magnitude of mail and junk mail that comes in, especially if it says, "Dear landowner," I would be hard pressed to think it was personalized. And nowadays with computers, even if it's got my name and everything else on it, unless it's very specific and personalized. And just to let you know, when us in private business want to make sure somebody gets it, we send it and we note on the bottom, regular mail, sent certified, return receipt, hand delivered, posted on door photo taken, slipped under door photo taken, and witness. So there's ways to make sure people get mailings, okay? So, but also 1,800 or so land lots, that is not really that many. And right now on the computers, you guys are in Honolulu, I'm in Hilo. I used to fly to Honolulu to go to the Bureau of Conveyances and look up addresses and names and stuff when I had to collect money from people. You guys are right there, and it's now on the computer, Bureau of Conveyances and your tax records. You can find out everything. You can find out every easement on that property. You can get a copy of it. And also, just for your information, the incline on land when it was Robinson's land, and I think you were there for those hearings, the incline when it's cattle grazing on 5,000 acres, that can still handle a lot of ag production. An incline on 30,000 square feet, excluding that, and plus the house can't handle very much ag because you can't have a cow on less than an acre without huge supplementing, which would mean, because I have cows, which means it's not cost effective at all. So huge differences. And all of the other IAL land we've been looking at, we didn't look that they had, oh, whoopee, they met one of the criteria. So let's throw them into that. Instead, you're saying if it meets one, it's okay, we're going to make them IAL land. We tried to make sure they met almost all of them. I mean, so this whole thing, I mean, I'm crying for some of these landowners who are clearly may or may not have received notice. Absolutely every realtor needs to include this. I am appalled that this is taking place and that you say it took $300,000 worth of tax money to do that. I'd be out of business if it took me that much. I manage more than that many lots that I get in touch with several times a year and make sure
Commissioner Cabral.
I don't have picked. Well, my only other question is, so now my understanding from the recent statement, is this a correct understanding that is now up to the LUC to determine if we're going to keep these parcels individually in this IAL or release them? So is that what this is right now? So we need to do the legal, proper, humane job. We need to get hold of all these people and find out what's the best thing for that land. Is that where we're at with this process?
If you should accept our recommendation, then yes, you can look more closely, look at individual properties if you like, and further, exclude or include properties.
Okay, and then if it took you guys 6 years, I guess that could be on a waiting list for our staff. And if we don't accept your recommendation, what happens?
Well, if you're not going to accept it, then you have to let us know how we didn't fulfill the requirements or meet the standards that were provided to us under the statute. And at that point, if you find certain inadequacies of our process based on the statute, you can tell us what we think we should do in order to meet those standards.
Okay.
We could,
I do have to say that you at your opening information did an excellent job of showing how the county met the requirements. And I'm not crazy about those requirements, obviously, now, because it appears to be some throw net type situation where we're just gonna, everybody that's got an A in their zoning, we're gonna make them IAL. And I think they get lower taxes. Maybe that'll help as they can't market their land or do things in the future. But 1,800 lots, about how many acres was that? I can't remember getting that clarified. If,
I believe it's about 45,000, or roughly 45,000 acres.
The total land area that was considered was 63,855.
Is that's including all of those 1,800? And did anybody ever analyze how many of those are less than 1 acre?
Of the study area or the potential IAL?
Well, your 1,800 acres, how many, 1,800 lots, how many of those are less than 1 acre?
We did not do that analysis.
Okay, well, just for your information, all that information's right there at your fingertips on the computer with the city and county tax records and your Bureau of Conveyances. Lots of information right there in one screen. You don't even have to leave your seat. So if it took you 6 years to get to this point, anyway, I'm upset and I'm sorry, but it is unbelievable that the process has been done, which is just, it may have met the criteria and the requirements of the law or the statute, but I think it's really inappropriate to the people involved in the city and county, and not maybe all of them, but
Commissioner Cabral, I want to have full opportunity for all the commissioners to ask us many questions and gather information from the city and county. And we will have full and complete discussion
Sorry.
over whether or not we choose to accept the city's.
Thank you, thank you. Well, my closing part as a cowgirl that I am is that even with lipstick, a pig is still a pig. Thank you for the lovely lipstick job. Bye. I'll mute.
Thank you very much, Commissioner Cabral. Commissioner Ohigashi, you're next.
Thank you, Mr. Chair. Sometimes I'm left speechless. I'm going to try and concentrate.
And I should have been speechless. Thank you.
I'm gonna try and concentrate my questions. And nice to see you back again. But I'm going to try and concentrate on how the criteria was developed and what was the process used by the city. So essentially, my understanding is that the city read this statute and said, hey, all these other big landowners are only 50, 51 or 50% and over kind of designation, so they can, their other lands are untouchable. So we're going to have to go and go forward with some kind of proposal so that we can try and implement the statute before these big landowners. Is that my understanding?
So as far as the voluntary IL process, yeah. So I think that they could do that so that they could ensure that 50% of their property would not be designated as IL, so that they could do what they wanted with the remaining 50% of their property.
And I recall on several voluntary IL petitions that the city and county would always respond and say that, hey, we're in the process of doing our review and we're trying to figure out, so could you hold off on this voluntary designation and wait for our review? Is my recollection correct?
Commissioner Ohigashi, this is Raymond Young. Yeah, essentially, yeah, we made some earlier on comments to that effect. We were hoping that we could conclude our process before many of these lands were designated IAL by the Land Use Commission. However, over time, I think our position has changed, and we generally supported the major landowners' declaratory ruling requests before the Land Use Commission. As you may or may not know, the IAL law in Chapter 205 was passed many years ago, and we only got to mapping it in, I think, beginning 2012. So the large landowners had quite a bit of years to work on submitting a declaratory ruling request to the LUC. But I think most of them started doing that when we started our mapping project.
And essentially that was the purpose of the legislature, is trying to get the big landowners to try and do their own designation so that we can have a body of preserved agricultural lands for the purposes of future generations. So what I'm trying to get at is, in 2012, when you started your mapping, did you develop a sort of like checklist or a procedure list that would that you would follow in preparing for this submittal, these recommendations that you have done?
Our guide on this was really following the statute and to make sure that we met the process requirements. And so in looking at the criteria, we went with the 8 criteria that's defined in the statute, and I believe there was a ninth one added on by the Technical Advisory Committee. And it had to do with agricultural easements, so the whole process was based on meeting the statute requirements.
And I'm not familiar with the city and county's requirements, but does this type of action, which involves a land use, essentially a land use change or designation, one of the designation, does this action require that the city and county send this out to things like the neighborhood boards or the planning commission?
Under the statute, no.
Not under the statute. I mean, the city's own rules. They have, this is a resolution that was eventually passed by the city council. So I'm assuming that you have your own rules in regard to getting a matter before the city council involving zoning. I'm familiar with the Maui County Charter, which seems to imply that all seems to
So,
grant the planning commission certain powers. So I'm just curious if within your own rules, whether or not you're required to submit this to the neighborhood boards in effect, or the planning commission or any other.
so first of all, the rule, there's rules, the HRS rules, I'm sorry, the rules for the IL statute, there are state rules, which we did follow, 1515, or Title 15 of Chapter 15, Hawaii Administrative Rules. We don't have specific rules, city rules for IAL. However, this is not considered a rezoning, so it wouldn't fall under zoning rules of the city. This is just an overlay. We don't believe that this is a change in land use or affects necessarily the specific rights of developers or landowners. So it wouldn't require under our rules that we go to the neighborhood board or the city council. I mean, well, the city council, as part of the statute, we are required to submit it to the city council for review and acceptance. But other than that, we're not required to go to planning commission or the neighborhood board.
Did that decision to not, was that a decision that that city and county decided to, decided affirmatively, or just didn't think about it?
I think again,
because there's nothing to stop you from submitting it to a neighborhood board or planning commission for their review.
right. No, yeah, you're correct. There's nothing stopping us. We could have done that. We could have taken it to the neighborhood board. Maybe looking back, we could too, but we're guided by the statute, which required public notice by mail out. But in addition to that, above the standard that was required, we did do press releases, advertisements in the newspaper to further, spread the word about the county IL process.
So, Mr. Moon, I'm not talking about notices at this point in time. I'm just trying to find out how the decision-making process was made and whether or not consideration was given to send this out to the neighborhood board. There was one comment that was made, and I was just questioning that as to whether or not you decided not to do that affirmatively, or you just didn't think about that. Second thing is that the planning commission, which I think would have jurisdiction to at least review what it's had and hold open hearings on it. Was there any reason that it was sidestepped, or was it not considered? I'm just asking those questions.
Right. So, yeah, I mean, I think we're guided by what the statute requires us to do. That's what we did. And
I'm not saying I'm not making a judgment as to whether or not you did or not follow the statute. I'm just curious about whether those options were considered.
Okay, I would defer to Ray and Dina if they have any comment on that. I'm not sure if there was an affirmative decision on those types of public hearings.
I think early on when, as with all contracts, we had a consultant work on this study in collaboration with the department. And when they worked out their scope of work and community outreach, I guess the decision was made that they were going to hold these rounds of community meetings and publicize it in the newspapers and things of that sort to get the word out. So it was a choice in the process not to do presentations to all of the neighborhood boards.
Okay. The other question that I have is the TAC, and I'm looking for what is that acronym for? But the TAC, did they have to sign off on your submittal to the, I guess, the county council, city council?
No, they did not need to.
Did they?
Well, we did not need to get their sign off to submit to council.
I know you did it, but you're saying that, I understand that. I said, but did they? Did they review it and determine to say, yeah, this is what we've been working on. Let's submit it to city council, and I agree with you.
No, I don't believe they did, but there were, different, voting on the criteria. So they did make certain actions that affected the final submittal to city council, but there wasn't an official sign off.
So would it then be fair to say then it was DPP's recommendation solely for these recommendations to be placed before the city council?
Could you repeat that again?
Well, I'm just trying to get at, was there anybody else who reviewed it before it was submitted to the city council? I'm just trying to get an idea of, besides DPP.
I'm sorry, Commissioner, just to go back to your previous question. I got clarification that the report, our final recommendation to council was presented to the TAC and they had no objections to it. And that solidified our decision that it, to transmit to council.
And I was trying to look for that. Is that in the record someplace?
We would need to check through all of the notes if it's indicated in there.
Commissioner Ohigashi, if I may, we've been going 1 hour. How much longer do you have right
Well,
now?
I just have a few more questions.
Okay, so my intention, folks, would be to go to 11:30 and then take an early lunch to noon, half hour only. We lose Commissioner Axon at 12:45. We will then be down to 6 members and 5 are needed to take action on this item. So does that sound like a reasonable plan?
There, my lunch, for lunch, if it's possible, can we do an hour just because my stomach needs to be filled instead of just a small amount, or even 45 minutes?
I can resume my questioning after lunch.
Why don't
I'm willing.
maybe we wait till 12:30 and take the lunch break then, and then we.
I'm trying to accommodate the needs of our council actually at an 11:30 break. So.
Okay. Thank you. Whatever you determine.
So I'm fine with, I'm trying to balance the sort of basic needs that we all have, along with the fact that we have so many people attending and trying to manage their schedules and their lives in addition to participate in this matter. So let's finish up your questions, Commissioner Ohigashi. We'll try and end by 11:30. We might briefly, if we go slightly past 11:30, we might lose Miss Chena briefly at that time, and we'll take a break, 45 minutes, Commissioner Wong, so resuming at 12:15. So Commissioner Ohigashi, thank you. Please proceed.
And I just was curious, when it went to the council, was there testimony in regard to this matter? I was just looking at your number 9, 8, and 9, and I was trying to glean from that what the testimony was, but I was just wondering if there was testimony.
I'm sorry, Commissioner, I cannot recall if there was written or oral testimony at the hearing. We could check online if you want to wait a few moments.
No, I don't need to wait. If you can just submit it, if you can just let me know, or you can indicate to your council later on as to what part you're looking at. I just was wondering. And then
Sure.
the last sets of questions really it deals with that. I'm assuming that the council passed this by unanimous.
Yes, it was unanimous.
And following what all councils do, they publish in the newspaper, the resolution, et cetera, et cetera. Is that right?
Yes.
And would that include all of the TMK numbers? That
Yes.
was attached?
The resolution that was adopted, 18-233 CD1 FD1, had 2 attachments. One was the listing of all the TMKs, and one was a set of the maps.
Was that published also?
It's all public record, so it's on the city council's website.
I'm just asking if it was published in the newspaper, the resolution, and if you know.
There's a requirement that the hearing needs to be publicized, but the outcome and the actual reso is not published like in the newspaper, but it is publicly available on the city council's website.
And my absolute last question is that there was concern yesterday, I believe, by one of the testifiers that they were kicking out. This IAL is kicking out some people who couldn't be farmers or couldn't work as farmers. Do you guys have any comment as to whether or not this IAL designation is intended or will be doing that sort of draconian method, draconian outcomes?
I don't think that is the intention at all, to kick out landowners who are not farming their land currently. But as I stated earlier, under the law, current for just agriculturally zoned or classified land, the intention under the law is that the land be actively in agriculture. So potentially there probably are many people that are just residing or retired on their land, but that doesn't mean that they are in conformance with the statute or the ordinances. But again, I don't think that's the intention, and I don't believe that's the county's intention to go after people who are necessarily in compliance. But that, I think currently those people are probably not in compliance with the law.
Would you be able to provide to me the county's ordinances relating to defining what a farm dwelling is and what it would be used for?
Sure, we can provide you that.
Thank you. No further questions.
Oh, okay.
Sorry, Ms. Wong, did you have something?
I was going to provide the county's farm dwelling definition is contained in our revised ordinances of Honolulu, Chapter 21, the land use ordinance. And it's defined as a dwelling located on and used in connection with a farm where agricultural activity provides income to the family occupying the dwelling.
Okay. I think there's been a request to have that, make sure that's in the record. So if you could please provide that as well. It is 11:32. I recognize Commissioner Giovanni has his hand up. I recognize I sort of prematurely stopped Commissioners Wong and Chang from asking their full set of questions. I will note the chair has an extensive set of questions for the city and county as well. So, which I'm eager to give. We are going to go into recess until 12:15. When we will resume the questioning of the city and county by the commissioners. Thank you everyone for your continued work and patience on this important matter.
It's a fair comment, taking the macro view. My concern is that if I take the micro view, which is the view of the individual landowner of a small piece of land, he may get a completely different view. And when I went back and I actually took the time to read all the minutes from the TAC, which was your Appendix B of the August 2018 report, and in particular, the development of the criteria, there is absolutely no mention of a criterion such as this as being important. So where did this criterion come from to make that judgment, if not from the TAC or from the 9 criteria that were put forth?
As far as the need to keep it, what I just spoke about?
Yeah, the need for eliminating islands or pukas within a sea of IAC and how that might affect an individual landowner of an acre or so that otherwise does not qualify by the 9 criteria as for IAL.
So I think that those pukas, they would at least qualify for one of the 3 that we have narrowed it down to based on the TAC. But I would have to defer to Ray and Dina as far as what policy discussions, because this overall is a policy, right? It's a policy that we're putting forth and that the commission is moving forward. This isn't about individual land ownership rights. It's a policy that we're generally trying to apply to move forward the strategic land base to protect and conserve agriculture. But I'll defer to Ray and Dina, who I think are logging on again. Or maybe not.
I'll wait for their additional comment.
Okay.
Mr. Young or Ms. Wong, are you? Oh,
Yes, we're on.
We're on.
Where's the camera?
Is that the camera?
Yeah.
Yeah. Okay. You should come over here.
we can see both of you, though it is an odd view.
Yeah,
Okay.
Dina will be moving in front of the camera.
No, I think they can see me, Ray. It's okay. I have too much stuff.
Oh, yeah, here it is. Well, how the view is like that? Sorry, Mr. Chair, we had to move from our conference room, and I'm not used to using this new computer here.
You would not be the first person during the pandemic who struggled with Zoom. Don't worry.
Yeah, okay.
Okay.
So it looks like this is like a dual lens camera.
It's fine. We can see you sufficiently. If you could answer Commissioner Giovanni's questions, please.
Okay, Commissioner Giovanni, could you restate the question?
I'd be happy to. My concern is having to do with consideration of a small parcel of less than an acre nominally that is found to be located in a sea. I think those were the words the county used, a sea of land or a large mass of land that was otherwise IAL. And my concern is that none of the 9 criteria that the TAC put forth identified this particular aspect or criterion as being a factor that should be taken into account for inclusion of a small parcel of an IAL. So what was the policy or the judgment or the process that was used to what looks to be arbitrary in my mind to include these very small parcels that just happen to be in a sea of IAL?
I think from one of the 8 criteria, it refers to contiguous large blocks of agricultural land. I believe that was one of the bases for us including small pieces, small lots. To be,
Excuse me. Excuse me, I'm having a very difficult time hearing Ray.
Sorry, the mask is too tight. Okay, can you hear me now?
Yes.
Okay, so what I was referring to is I believe there was a provision in the IAL law that talks about having large contiguous blocks of IAL land. So that was the primary reason we included small parcels, even though they may not have met the top 3 criteria, they do meet the large block of IAL land criteria.
So
And just to clarify, that's in 205-44, that's number 7, contributes to maintaining a critical landmass important to agricultural operating productivity.
So you're saying that criterion number 7 is the basis for which the county is recommending that a small piece of land that happens to be situated contiguous to a large mass of land that is IAL should also be IAL, regardless of whether it meets any of the 3 top criteria. That's what I heard you say. Is that correct?
No, it still needed to meet one of the 3 criteria to be recommended as potential.
And in particular, you're citing criteria number 7.
Met the large block criteria, so not limited to the.
Is that correct?
Let me clarify. The TAC chose the top 3 for which the draft maps were first created. DPP in subsequent iterations was not limited to the top 3. It did allow other lots to be considered if it met any of the 8 criteria listed in the statute.
9 criteria, yeah.
The 9th one was added by TAC. It was not part of the 8 in the statutes.
Okay, let me proceed. So in review of the minutes from the TAC, which I think you were trying to follow, in their discussions of the top 3 criteria, and I'm citing specifically their minutes from their meeting of July 31st, 2013, which is in Appendix B of your report. It does not have a page number, unfortunately. And let me quote from the minutes. It says, quote, "There was confusion about what was meant by the bulleted item in slide 5. Inference to require that all 3 criteria are present to qualify for IAL. Following discussions, the group agreed that the wording should be changed and that it was not the intent to require all 3 criteria to be present to qualify for IAL designation. Lands that have all 3 criteria present should be given the highest priority for IAL. A combination of the 3 criteria was preferred. I go on. It was agreed that the report should include a statement about the criteria being specific to the city's IAL designation process, and that the city use the city use of the three criteria should not influence the LUC review of individual landowners' applications. That is, parentheses, i.e. a petition for a voluntary designation should not be required to have all three criteria. So my reading of the intent, and there's a lot more discussion in the minutes, was not that the TAC is saying, as has been conveyed this morning by the county, that in order to be inclusive, we're only searching for one of the three criteria. They clearly said they don't want to exclude a land that has only one of the three, and it strongly prefers to have all three. Where did it seems like it's gotten twisted somehow in the process since 2013 to interpret it to be, you just have to be one of the three because we want to include all the land that has at least one of the three, where that's not the way I read the intent of the TAC at all. So I just wondered if you could comment on that, or if you could correct my interpretation.
So I could speak a little bit more about that, Commissioner. So under HRS 20543, it requires state and county agricultural policies, land use plans, ordinances, and rules that shall promote long-term viability of ag use of important land, and shall be consistent with and implement the following policies. And it lists 8 policies that include: number 1, promote the retention of IL in blocks of contiguous, intact, and functional land units, large enough to allow flexibility in ag production and management. 2, discourage the fragmentation of the IL and the conversion of these lands to non-agricultural uses. So, I mean, just those 2 out of the 8 for 20543, I mean, this is part of the policies, I think, that were considered when the decision was came up as to whether we include these little pukas or not. And again, I think it speaks to what I had talked about earlier, that looking forward, if we don't include those pukas, there could be consequences down the line where there's spot zoning and upzoning that can fragment or disrupt the overall land base for IAL.
Ms. Apuna, I appreciate that. And that's the response I was looking for to my first question. And thanks for following up on that. The question I just raised a moment ago before you spoke, however, was about the notion that for purposes of inclusion, that any one of the top 3 criteria can be met and justify inclusion. Whereas the way I read the TAC is the opposite. It's like they should not be excluded if they happen to have one of the 3 top criteria. And in fact, it's strongly preferred they have all 3. And I just wondered where did this interpretation, or my interpretation, go wrong, in that it looks like it's not to be exclusionary as opposed to err on the side of inclusion.
I think that there's, because I know that there was the voting at the end when they decided, so once they determined 1, 2, and 5 were the top 3, that there was a vote as to whether it needed to be all 3 to be IL, or just 1 was enough. So they did vote on that, and they concluded that 1 was sufficient.
You're absolutely correct. That's exactly what did happen according to the minutes, is that they started off with requiring all 3, and they changed it to be that 1 was sufficient. That's different in my mind than saying if you meet any one of these 3, you are included. It means that you could be included. Anyway, enough said on this. I've gotten the answers I'm looking for. I return it to you, Chair. Thank you, Ms. Apuna.
Thank you very much, Commissioner Giovanni. Commissioner Chang.
Thank you, Mr. Chair, and thank you, Ms. Apuna and the county. I am leaving, Commissioners Giovanni and Ohigashi asked a lot of questions regarding the process related to the criteria. My concerns are primarily related to the public involvement process and the landowner notification, whether you have satisfied that under the rules. But let me make sure that I want you to confirm that you concur with my understanding on the following so that I am on the same page with you. And these are going to be a series of questions about the IAL designation process. That you would agree that there are essentially two processes to place private lands in IAL. One is a voluntary designation, which we have heard could cost up to $75,000 and it requires an EA. Or two, the county recommend IAL designations in compliance with the detailed regulatory process, and LUC makes the final decision on the recommendations. And this is at no cost to the private landowner. Would you agree?
Yes, I would agree.
And again, that you agree that Land Use Commission makes the final decision on which properties should be designated in the IAL and approve the final maps.
Yes.
Okay. So like the large landowners who voluntarily decided which of their private lands to include in IAL, and we realize that in some instances, these private landowners, they did it to get, to ensure that the rest of their property wouldn't be forced into IAL. But do you would agree that, sort of based upon that kind of experience, LUC has the authority to take individual private small landowners' properties out of your city recommendations?
Yes, we agree. Yes.
And in the future, assuming that the city does develop the incentives for IAL and makes it more attractive, if a private landowner wants to designate their land as IAL, after this process is complete, assuming it is completed, to take advantage of those incentives, they would have to file their own private landowner declaratory action and go through the private landowner process. Is that correct?
I believe so, but I would have to look at the statute. I tend to believe that once this process, this county process that the commission is deciding on, that would be the final say, that there wouldn't be the ability to individually do a voluntary IAL designation, but I might be wrong.
Okay, yeah, I'll go back and look at that too then, because okay, yeah, I thought that there could be continuing placement of properties in IAL. Again, the major incentives to encourage have not been developed. So a lot of these landowners that have come forward with concerns, I mean, I understand there hasn't been those incentives to encourage them. Okay, I'm going to look at the rules, the law, and you look at that as well. Okay, let me ask you this question. Given your policy considerations, as a county, what impacts would Land Use Commission's withdrawal of private landowners who request to opt out have on your policies?
I think just other than just having that overall land base, I don't know of any specific impacts to our policies. I would defer to Ray if he has any comment, or Dina.
I imagine, this is Ray, that if many of these owners are objecting and
you may end up with a checkerboard type of IAL polygon, which may not be conducive to feasible agriculture for the remaining folks who want to be in IAL. But that's I don't know if that can be proven though, but it does kind of counteract the provision in the statutes for large contiguous blocks. I think DOA would agree that it's easier to farm on larger blocks of ag land than not.
Okay, but that would ultimately be Land Use Commission that makes that determination should a landowner come forward and request to opt out. I mean, that is one of the consequences. We could withdraw that parcel from the designation. You would agree? Okay.
Correct. And in furthering this process, we would rather not penalize those that want to be designated IAL if those who don't want to be designated IAL disrupts the entire process.
Well, sometimes we don't get everything that we want, and you've got to do the best that you can. So
that's right.
So let me ask you questions about the public involvement process. The rules require an inclusive process of public involvement. As I understand it, you had your TAC meetings, you had community meetings, you had publications, individual landowner notifications, postcards, and then you had the city council public meeting. Were there other forms of engagement with the public?
There were also focus group meetings. I'm not sure if you mentioned that just now.
Yeah, okay, focus group meetings. I mean, and you know, quite frankly, a lot of my practice is public engagement and community outreach, and it is a very difficult practice. So I understand you have to try to do the best that you can. And
one other thing to consider, we did have during the course of the project, there was a website dedicated for this, and there was a map where you could zoom in on your parcel to see. So it was a very informative website. And since then that's been taken down, but we have the report on our DPP website.
Could the public have left comments on the website?
No, they couldn't.
Okay.
To clarify, the webpage is still up on our DPP server. However, it says it's dated for, I believe it was August 2018, the day we submitted it to City Council. So even though it's still up there, it's not to date.
Does it still contain all of the information about the IAL process and information up to date, up to 2018?
Yeah, I believe that is correct. And there's an FAQ on the website. The map is interactive. You can click on the soil layer, the water layer, the existing ag layer. Yeah, and you can zoom in and see your property, even if it's very small.
Okay.
And then following the city's process, it went to City Council. So they have on their website the adopted resolution and the TMK list and maps. And I think there may also be a link to that on the DPP website.
Okay, I can tell, it looks like Commissioner Cabral is probably looking at them right now. And she's, so, okay, but, you know, and it would be easy for me to second guess if I was doing this, would I have done the outreach differently? I mean, I would suspect that Ms. Apuna, you probably would have included the neighborhood boards. I mean, a lot of those low-hanging fruit to keep people informed, you would have done other outreach forms. However, I guess we have to evaluate it based upon what you did do. And So I just wanted to confirm that those were all the things that you did. Did you publish not only in the newspaper, but did you also publish in the OHA's, the Office of Hawaiian Affairs, Kavaiola? Did anybody, was any of this information published in that publication? I didn't see anything.
I'm not aware of that being published.
Okay, all right, all right. Okay, I just want to make sure that I understood the extent of your public involvement. Now I want to ask some questions regarding landowner notification. In my experience, 5% return rate, not that bad, given that you did 1,800, you had 1,800 mail outs. And then I also heard the city's testimony that out of that 5%, you did some additional research and you subsequently mailed out the letters that were returned and 2 came back. Is that correct?
Yes, that's correct. We're still trying to come up with the rest of the statistics on this because there were 2 mail outs, and I think the second mail out was resent of about somewhere around 120, 130, and of that 2 came back. The first mail out, which was ending of 2016, we're still going through those returns to see how many were resent. But once we get that number out, we can give you that information.
Okay, because when I read the rules, it says either by mail or posting on the property, posting the notice on the property. Did you post the notice on any of these properties, the 2 properties or any other properties where they were not received?
No, we did not do that.
Have you, and could you make sure that you identify which of the properties the TMKs did not receive either written notice or posting? Can you make sure we get a copy of that?
Okay, we will try to search for those.
Okay. And based upon what was recently uploaded to the LUC website, it looks like the notices went out in, were they 2017 to 2018 to the landowners?
I think the original notice was in 2016, and the second notice was in the latter part of 2017.
Okay.
Let me check the notices that I sent over to your staff's office.
Yeah, okay. But we did hear numerous testimony yesterday from people who said they didn't receive notice. And I know you were taking down their TMK numbers. Did you confirm whether they received notice or not?
The process we used was the regular USPS system. We did not, nor did the statute require us to send out with some kind of a receipt saying the recipient received it. We did not go through that. No. So the assumption is if it didn't get returned, that the recipient got the mail, the notice.
Okay, I see.
But as far as the TMKs that we wrote down yesterday, we checked it against the list, our mailing list, and I think most, if not all of those, were on the mailing list. So they should have been, it should have been mailed out to those.
Okay. And again, the assumption was if the letter did not come back, the assumption was that it was received.
Yes.
Okay, all right. And I guess notwithstanding, again, whether they received notice or not, you would agree that Land Use Commission, again, has the ultimate authority whether to, I mean, we can offer to opt out or opt in all private landowners. You would agree?
Yes, we agree.
Okay. And this may be more of a comment, but on the ag designation, I mean, I do agree, Ms. Apuna, with your comment about if the land is zoned ag, it should be used in ag purposes and not residential unless it is associated with the ag. I mean, Land Use Commission has taken some very strong positions on farm dwellings, that it must be associated with the ag purpose. So, I do, I think this important ag IAL designation, if the state of Hawaii is really committed to sustainable ag, and I think this is the intent behind IAL is consistent with the Constitution and something I support. What the city did, yeah, would we have done some things differently? Maybe, but my concern was your public involvement and your landowner notification. There are other commissioners who are much more, who will understand the criteria much better than I and have asked those questions. So I have no other questions, Mr. Chair. They have answered the additional questions I had. Thank you.
Thank you, Commissioner.
Thank you very much, Commissioner Chang. I know Commissioner Axon, as had previously been announced, had to leave the meeting. Commissioners, are there further questions for the county at this time?
Chair,
Commissioner Wong.
I have some questions, but I know you have questions also. So do you want to go first for me? Just
I don't mind going first.
Yeah, please. Thank you.
It's fine. So, aloha, Ms. Apuna. So I'm going to introduce my questions a little bit with just some commentary. A year ago, I think many of us, I certainly was, sort of scrambling, freaked out to see whether or not I could get enough food in the cupboards. It was a scary time at the start of the pandemic when everything was shutting down and we weren't sure where things were going. And it's not so far away that I don't remember that. And so I think for me, one of the biggest tragedies of the last couple of days is that the basic goal in the Constitution that the people of Hawaii collectively approved in 1978, that goal that the state shall conserve and protect agricultural lands, promote diversified agriculture, increased agricultural self-sufficiency, and assure the availability of agricultural suitable lands. We've lost sight of that in this discussion. We've lost sight of that worthy goal. And it's a really, really important goal. It's like a basic human need: food, shelter, water, transportation, healthcare. I think we've lost sight of those in the last couple of days for a couple of reasons. One is what I think even the city might admit was not a great outreach process, and many people would say is a seriously flawed outreach process. And the second is we had a private law firm, some private attorneys, send out letters that I think have really exploited people's fears regarding those things. So, and I'm particularly, I got to note this because I really want to note this for the record. There's a couple of people who were part of who actually love to publicly take credit for passage of the IAL law, who have consulted or testified in front of this commission, supporting private landowners in their IAL designations. And now in the letter from the direct firm, we're also then apparently part of the process of whipping up small landowner concern over this very same law. And it's cynical at best to see that that's occurring. So my questions are going to be around three main issues for you. The first issue, I need to check in whether current county leadership is behind, aware of, and endorsing moving forward with this process. My second set of questions, the most extensive set, really has to do with these claims from private attorneys who have not themselves testified, but only encouraged others to testify, whether or not there is any actual effect on people's private property rights from an IL designation by the county. And then third, based on those answers, whether or not, even if the landowner communication was very poor, whether there's been any due process concerns that have been raised. So that's the three sort of areas of questioning we're going to have. Again, the first area is about current county leadership. So we certainly have a new mayor and a majority of new members of the council right now. So is the current mayor, Mayor Blangiardi, aware of and has he endorsed moving forward with this process at this time?
I can't say specifically that he's stated that yet, but I understand that the administration is supportive of helping farmers and preserving and conserving agricultural lands and making sure it perpetuates into the future.
But not on those broad goals, but specifically, you don't know whether or not Mayor Blangiardi is supportive of DPPs moving forward with this set of lands and the request to the commission?
We haven't, as new administration, spoken directly to Mayor on the IL. No, we have not.
Thank you. Secondly, is the current council aware of this process going on, and have they endorsed this process moving forward at this time as they've stepped into their leadership roles?
I'm not aware of any communication with the council as far as the IL, the current council.
Thank you. And then, I'm really grateful to Charles for having raised this issue. I just want to confirm there's no current, past, or future plans at this point to communicate with the neighborhood boards regarding this issue?
Not as of this moment, but I completely understand Ms. Poy's concern, and it's a really good suggestion. So I wouldn't say that we wouldn't do it in the future. It's important that communities are aware, and yeah, the neighborhood boards are a good way of getting that information dispersed. So I won't say that we won't do it, but we definitely appreciate her comment and direction.
Okay. Now I want to ask you some questions, moving to my second area, about what the actual effect, if any, is from potential county designation of IL through this process, through the LUC. Have you seen the letter, at least one letter that was sent out by the direct law firm to landowners?
I did. I glanced through it. I wasn't able to really look at it closely, but I have seen it.
Okay. Do you have general impressions with regard to the assertions in the letter?
I think they're trying to alert landowners of potential issues, but I'm not sure that they necessarily clearly state what the potential implications are for IL designation. I think I spoke a little bit about this as far as, the occupancy of the farm dwelling under 205-45.5. It's a little more explicit, but it's not necessarily far off from the farm dwelling definition under 205-4.5.
To that specific point, can you tell me if the land is designated as IL and 205-45.5 now controls, how might it differ in any substantive way?
So the issue about, you have to be the occupants, the immediate family must be currently and actively farming the land. So that's much more explicit. And I think a testifier mentioned, does that mean children need to be actively, currently, and farming the land? And based on the statute of plain reading, that can surely be interpreted that way. I'm sure it wasn't the intention, or I'm not sure, but the intention is probably not to require children to be farming the land to live there, but it could certainly be interpreted that way.
I'm having trouble hearing with the background noise.
Yeah, I'm sorry about that.
Do you want to go tell your coworkers to be quiet?
I also just wanted to add, you were asking about
how the HRS IL designation would affect landowners. So in addition to what Deputy Director stated, their farm dwelling or employee housing cannot occupy more than 5% of the total IL area controlled by the farmer or the employee's employer, or 50 acres, whichever is less. So there's also those conditions that would be placed.
Okay. To that point, Dina, there's been some public testimony of people who say, I have a fairly small lot, which is mostly occupied by my house now. Would they immediately be in non-compliance upon designation as IAL?
I guess it would depend how much of their land is IAL.
So if the county has recommended a small parcel and over half the parcel is occupied by a house, would they be at least technically in violation of their IL designation?
Well, there is in section 205-8, this is Ray, by the way, which is the section on nonconformity. So one could interpret that with the implementation of this map, that those that have been currently legally established as single-family dwellings, for example, because the lots existed prior to 1976, I think they would be able to continue being a single-family dwelling, even though if they were designated IAL.
Would it, just briefly on this line of questioning, which is diverting from where I'm trying to go, however, say they had to rebuild or wanted to modify, would, under normal procedures, the city then kick them out of being able to do so?
Not necessarily kick them out, but I think they would be in violation of the law, the ordinances, as they would be currently if they're under ag zoned or ag classified land.
So Ms. Apuna, the question, the core question is, do people have due process rights that are being, or perhaps have been violated by not receiving fair notice during this process? And answering that question depends in part on whether or not there's any material impact or not from IL designation. That's what I'm trying to get at. What can you do to help me understand that?
So, like I said, I think currently the current uses or the current allowed uses in ag, regardless of IL, requires or prohibits certain usage. So they do align pretty much with IAL, the same restrictions. So there are a few little slight differences, but generally, I don't think there's a great change in the landowner's ability to use their lands. So I don't think that there's no taking. This certainly doesn't rise to a level of a taking or a change in zoning. I think we've talked about that. There's no change in their entitlements in zoning at this point. But there are some maybe finer points as far as the farm dwelling occupancy, and that I think they're required to provide an ag plan if it's a new farm dwelling. But I don't think that it raises to a level where an IL designation would be significantly interfering with their use of their land.
In regards to that position, a question was asked earlier by Commissioner Giovanni about whether or not IAL pending designation or even existing designation might appear in a title report. Are you aware of whether or not for existing IAL lands it appears in title reports?
I'm not aware, but I think it would be.
Because that would give some indication whether the private sector views it as materially meaningful encumbrance on the land.
Right. I mean, even in the deck rulings, the decision and orders, the commission requires recordation. I don't recall.
I don't believe so. We do have DBAs. Going back to the letter from the direct law firm, were there other general impressions you had from the letter or points where you found disagreement?
Well, I would just generally say that, the people that receive these letters, it's good that they're alerted, but I would just be cognizant of maybe the motives that are involved in these types of letters. What are they trying to really do? Are they really trying to alert? Or are they trying to do something more or different?
Could you expand on that?
Well, I mean, if they're successful in convincing people that this IAL program is trying to take away rights from people or is a land grab, which it is not, they might they might feel that they need a lawyer to represent them and to really protect themselves. But the bottom line is this is not the intent of the IL law. It's actually to benefit and help people use their agricultural land to continue farming or to allow them to get into farming. It's not meant to restrict rights or to take their land away in any sort.
Okay. Do you know the word barratry?
No.
I think it's like a 50-cent word for ambulance chasing. Was that what you were trying to suggest?
You
You don't have to answer that.
Yeah.
Can I ask you, there was a lot of testimony yesterday. Some of the testifiers certainly indicated there's no agricultural activity on their lands right now. Some indicated they are renting out their properties for residential purposes. Sometimes this was due to simply a lack of available resources to do farming, such as water. What does the city currently do to enforce non-compliant? Because this is not, well, two questions. Is that compliant with existing agricultural zoning? And if not, what does the city do to enforce?
Yeah, so again, if you're not farming your land and don't have any agriculture on your land, it's probably under the law, under the ordinances, under the statute, you're not complying with the law. However, we're not going out there and putting people in jail for this. It's a lot of what we do as far as enforcement is complaint driven. So if your neighbor thinks that you're not doing the proper things on your land, you might get a complaint, you might investigate, but even investigations and the ability to have sufficient evidence to truly enforce is a challenge for the county. As far as, I guess people are admitting that they aren't in compliance, but I don't think they should fear that we're going to run out and go and cite them.
So if somebody is, for instance, farming on their property right now,
Are farming?
if they are farming now and their land is designated as IL, does it have any meaningful effect?
No.
But if they're not farming and if they're not compliant, there is potentially an effect?
I potentially, slightly, but I think it's the same as the non-IL designation.
So I guess my question for you really is, what's the standard in which somebody's due process, in the city's opinion, what's the standard in which the city, in somebody's due process rights might rise into play? If you say slightly, they're slightly affected, is that enough? Is that not enough?
I think it's just a matter of looking closely at what 205-45.5 means and what is currently required or not required. I think there's just some nuances there that even I haven't completely come to a determination on. But other than that, landowners on ag, they are currently permitted to have ag, to farm their land. That does not change with IL designation. They can continue to use their land as currently zoned or classified. So in that respect, I don't think that there's any type of taking, it doesn't rise to any level of taking or interference with their rights to farm their land as they currently are allowed.
So you believe this commission should not, sorry for the double negative, we should not accept the proposal from the county because of the potential due process concerns that some people may have alluded to.
Yeah, I think that you should be free to accept the county's proposal without fear of, generally without fear of a genuine threat to due process.
Last questions for me, for at least right now. You know, I know that like after carrying this burden for a decade, some people in the city would be quite happy to hand it over to us. You know, if we think back to the constitutional goal that the people of Hawaii collectively set for ourselves, just putting the classification on the land in and of itself does not achieve any of our goals of protecting ag land, increasing self-sufficiency, promoting diversified agriculture. What will the city be doing should the commission accept this, to support, encourage, inform, better engage owners both of IAL properties and of non-IAL properties in order to fulfill those constitutional duties that the city as a subdivision of the state also holds?
So I think the city has learned a lot from the last 2 days, and like the suggestions to go to the neighborhood board and do other outreach are well taken, and I think we can move forward and try to implement a lot of those outreach efforts to educate the public about IL. And additionally, you know, the other part of IL is creating the incentives and the protections for farmers. So, I mean, we have been doing that. And I think we will continue to try to develop those programs to really create those opportunities for farmers and to make farming more robust throughout the county.
Okay, thank you very much, Ms. Apuna, as well as Mr. Wong or Ms. Wong and Mr. Young. I appreciate your responses. Commissioner Giovanni.
Chair, I had a quick follow-up based on your line of questioning for Ms. Apuna. If I understood correctly, parcels of land that are zoned agriculture today and are not doing farming, the city and county would not take an enforcement action unless there was a complaint. Is that correct?
Yeah, generally speaking, that's our practice.
So back to my concern about the pukas that are in the sea of IAL land. So if a small parcel that happened to be located in the sea of a large sea of IAL land, and on this particular, and it was designated IAL by this process that we're talking about, and there was a residence on there and they were doing no farming, and the landowner that surrounded it, the big C, filed a complaint with the city and county, what action would the city and county take against the small landowner?
So I think we would we take all complaints and we would probably send an investigator out there and look at what, they look at what the land is zoned or if there's a designation on it. But it would depend on what was happening or not happening on that land. But I think it depends, it has to be case by case, because who knows, if it's too small for them to farm on, I think we would consider that as well.
But my question is, what kind of enforcement actions are in your quiver to use? And it goes to the question that the chair raised about the underlying land rights of the owner of the small parcel. What you find there's a complaint, you investigate, but what potential actions even exist? Enforcement actions.
So I guess if it's under the LUO or land use ordinance, if they are doing something other than farming, something that's not permitted within the Ag 1 or Ag 2 zone, and it's activities that are evidenced enough to write up a citation, I think we could write up a citation. I defer to Ray and Dina if they have more or better understanding about how we would or if we could cite people in the ag district.
Well, my question is a little bit the opposite consideration. What if they're not farming? They're just living there. And there's a complaint by the surrounding landowner that they should be farming. And you conclude that that's true, and what kind of enforcement actions are available to the county at that point?
So I think we allow them time to correct any violations. And then if they're not able to correct any violations, there are fines that can be implemented.
Okay, fair enough. Thank you. No more, Chair. And this time I mean it, no more questions.
I will say that the commissioners as a whole, including myself, are very bad at sticking to that promise. And to point, Commissioner Chang?
I'm a great example of that. But that was just, Commissioner Giovanni just triggered something. I want to clarify, Ms. Apuna, because there are people that are listening to our hearing. And what I understand is, one, if someone is just living on the property right now and it's zoned ag, whether it's designated IAL or ag, you would apply the same, the enforcement action could be the same, right?
Yeah, generally.
Yeah, so that the IAL doesn't create an additional or make them more, create a higher requirement that they have to be farming or exclude them from this requirement, right? I mean,
that's right.
And what I heard Mr. Young say is that in some instances, and I think that's why you said case by case, there could be a situation where some of these people may be grandfathered in if their residence was there before the law.
Yes, that's correct.
Because I'm thinking of some of these people who live in Waianae or Waimanalo. I'm sure they're trying to figure out what do they do now, and should they get a lawyer? But yeah, I think I don't want to cause unnecessary alarm. I mean, IAL doesn't necessarily make them more susceptible to enforcement. It's the same as if they just had ag land as well and weren't doing farming.
Right. So if the commission accepted our recommendation today, and then it actually designated all of the land that we've recommended, we wouldn't on that date therefore go after landowners based on the IL designation. Nothing changes between today, before the IL is designated, and the day after it is designated by the commission.
And let me ask you this, the opposite way. Let's say the commission decides to withdraw a parcel that is less than an acre and all they're doing is residential, but it's zone ag. That doesn't necessarily, if a complaint comes in from an adjoining landowner that they're not doing ag, even if they're zone, even if they're not IL, you still could take enforcement action. Is that correct?
That's correct. So yes, the agricultural use will not change. You know, the ability to use or the requirement to use your land for agriculture does not change based on the IL designation.
Okay, all right, thank you.
Commissioners. Commissioner Cabral?
I'll try and be nice because you've done such a good job, Chair, to help me. I appreciate the staff here that sent over the letters, and I appreciate our land use staff that emailed them to us. So I got them, I think, on the last break. So the mail outs that went to these individuals went out December 29, 2016. And then there's two different ones that went out November 8, 2017. And then a final undated one that came long ways that I guess it's in response to those who made comments. Anyway, none of them are personalized. So they're generic junk mail in a lot of ways. So nowhere does it identify on the two. And I'm assuming that that's the way it went out because it's set up. It's not like it's set up with the ability to add an address. And so I really, in terms of process, have to even question. And then two, computers nowadays that probably the address was so generic with little codes on it. I mean, you know, look at how much junk mail we all get. So I really have to question, you know, you know, apparently all of these 100+ people that testified or were in the audience yesterday, many of them say they never got notified. And yet staff is saying, oh, they all got it. Well, we all sent them something, but I'm going to say probably everybody's telling the truth because getting it and reading it are two completely different things, you know. In line 2, you know, we're notifying you directly because our draft maps include property that you own based on information available to us. Again, not real personal to me. So I really have to question this process. I mean, I spend money. I personalize everything. I sign everything in blue ink so people know it's original. I'll hand address envelopes. This was not well done to make sure you people got their attention when this mail came to them. And to have it happen over a 5-year period is, to me, really ineffective. That's as nice as I can be. Thank you very much.
That was very nice, Commissioner. Commissioners, are there further questions? Oh, Commissioner Wong, and I'm going to note that we're close to an hour in again, so.
Do you want to take a break, sir, and then I'll come back and start my questioning?
Yeah, and then, you know, if we are to get through this docket today, we would still need to hear from the Office of Planning. How long, OP? How long do you intend to present, Ms. Kato?
Oh, just for the presentation, I would assume about 10 to 15 minutes.
Okay. Okay. Yeah, it's 1:21. Let's take a break till 1:31, and we will come back and I will recognize Commissioner Wong at that time. We're on recess. Hello, everyone. We can reconvene. Ms. Cabral, Ms. China, Ms. Kato, Mr. Young and Ms. Wong. Ms. Cabral, are you there?
We were trying to get in touch with her. Oh, thank
Oh.
you.
I see a hand. Okay. We have myself, Commissioners Chang, Giovanni, and Wong, Cabral, and Ohigashi. Okay. Is the office planning there? Ms. Kato?
Not yet.
Yeah.
This is Rodney. Hi.
Hi.
Okay.
Those are two different people.
There's Ms. China. Wow. Office planning, where is your council?
Okay, hello. Yeah, our council is not here. Let's see if Brian is available. Okay.
I'd like to begin.
Yeah, I don't see either of them, but I'm from the Office of Planning.
Okay, we will proceed with Mr. Funikoshi. It's
Okay.
1:34. We are back on the record. Commissioner Wong had more questions for the city.
Excuse me, Chair. I believe that if OP needs to be represented by counsel, I don't think we can proceed until OP's counsel is here.
Okay. Mr. Yi, are you there? Can you go on camera?
Correct. If Mr. Yi is present, then you can proceed.
I don't see him.
Can someone play the Jeopardy music?
I would just make a comment, Ms. Apuna. Mr. Uchida made a very smart move to send you.
Commissioner Chang. Oh, we should really wait till we're
Okay.
back.
Well,
We're not
a
actually on the
question,
record, so.
More of a editorial comment.
Yeah.
And I agree with Commissioner Chang.
Rodney, if you can try and raise them on the phone, that would be helpful so we can get underway. Okay, now we can start. Ms. Kato is there.
Sorry.
Okay, we are back on the record. It is 1:36. Questions from Commissioner Wong.
Thank you, Chair. Good afternoon, Ms. Apuna again, Ms. Wong and Mr. Young. First off, Mr. Young, well, just DPP in general, thank you for sending us that information that I requested. So just thank you again. And the questions I have is kind of interesting in the sense that one of the public witnesses the other day was, well, is plantation camps part of the IAL process for the county?
This is Raymond Young. There were, I think, at least two cases where plantation camps were being included. One from the testifier yesterday, and another one just below the Kunialoa Farms. And the one that was from the person who testified yesterday, on that spreadsheet that I emailed to Land Use Commission staff and the Office of Planning staff, it shows that TMK with multiple CPRs, their owners were listed in our 2016 mail out. And I understand that the actual contents of the mail does not address the recipient, but the envelopes do. So if I receive, in my personal opinion, I receive a government letter addressed to me, and I open the contents, I'm gonna read what's there, regardless if the content didn't say my name. I mean, it's important enough for the government to send it to me directly with my name on the envelope. I would pay attention.
Okay. So I got a question. I'm unsure, so please explain this one to me. I thought plantation camps were kind of grandfathered, that we cannot touch them, or am I mistaken?
I don't believe the IAL law exempted privately owned plantation camps. It did say state property is going to be excluded because they're going to do their own identification, and other properties not under the city's jurisdiction, like those of the federal government, Hawaiian Homelands, HCDA, those were all excluded from consideration. But the private ones, such as those CPRs on that single lot, single parcel, I think it was 710011011, parcel 11, out in Wailua, was included as with the one up in Kunia, right off of I think was Kunia Road.
Yeah. So the question I have on, please explain to me, this is just for my own knowledge, verification, is, CPRs is like condominium units, right? Or all these same people on one TMK. So that doesn't seem like it'll be a ag land. I mean, so why wasn't that like kicked out?
Well, the process does not exclude condominiums. In fact, when many years ago, when sugar and pineapple plantation failed to begin, started failing for economic reasons, a lot of these large lots were sold by their landowners, for which investors bought them and started creating condos with them and sold off these condos. And so there's a number of these large lots around the island which have been separated by condominiums, and many have been sold off. And again, these are privately owned lots, or so to speak, CPRs, that are in the ag district that's supposed to be doing ag. They're generally not allowed to construct single family residences. And if they are allowed to construct farm dwellings, they have a limitation as to how many per the overall parcel. And they're not allowed generally to have one farm dwelling per CPR, since they're not legally subdivided.
Yeah, it just doesn't seem, I guess, just this local knowledge, or just knowledge I think of when I hear a CPR, I think of, a high-rise townhouses, and it doesn't make sense. Just logical sense to me to say, hey, even though it's ag, but there's a CPR on it, why are we even hitting these guys? You know what I'm trying to say?
Well, I understand where you're coming from, Commissioner, but the opposite also holds true. If we were to exclude these big, large ag lots with good water or soil and other growing conditions, just because it's a CPR, that would send a message for all these large lot investors to CPR all their lots to avoid getting an IAL designation. I don't think that's the intent of the law.
Okay, I understand about the opposite side too, so thank you. The other question I have, and this is just for my own notification again, is right now we're talking about ag land, right? So it's a state zone ag land. Are some of the city properties or city lands that we're talking about more zoned something else besides ag, like urban, rural, conservation, I mean, I know about the four that we deal with, but I know city and county has different zoning. So does you guys using a different zoning than ours right now for these properties?
So to speak, yes, because once the Land Use Commission classifies the state lands into agriculture, both the county and the state share within its land use jurisdiction. So we have various zoning districts within the state ag, starting with the most restrictive being Ag 1, which has a minimum 5-acre lot, which has the least, the most noxious uses in terms of ag could locate to. And then Ag 2, which is less restrictive because the lot size minimums are now 2 acres, but you couldn't, for example, put a piggery on Ag 2. And then the next level up in terms of higher level of zoning would be a country district, minimum lot size being 1 acre. But the uses could be either or residential or agriculture. And then finally, after that, we do have some parcels in the P2 General Preservation District, which are also in the State Ag District. So the Preservation District would be more restrictive than those of Ag 1 or Ag 2, but it also still allows agricultural use. And some of the problems that come from that, are like those preservation lands within Royal Cunha, where it was supposed to be developed as a golf course, but it ended up not being developed as a golf course, and the investors have started putting in egg structures, for which we've been hearing a lot of complaints from the surrounding residential lots. Although I believe those are urbanized already, so it's within the jurisdiction of the city. But essentially, the brief is that we have multiple zoning types within the state ag district.
Okay, so the question, those going back to the CPRs again, which zoning would they be in? For the city, not for the state?
Well, it depends which particular site. I'm looking at the one that the testifier was referring to, and the zoning there is Ag 1. And that TMK, let me call out the TMK so we can know exactly which one it is. It's TMK 71001-011, which has, when my first glance, like about 30 different owners. I imagine there's at least somewhere around there 30 CPRs, which is, again, is zone Ag 1. So the minimum lot size for that is 5 acres. Let me see what the size of that lot is. Where did it go?
I'm losing the thread here a little bit.
Okay, no, I just wanted to know about the CPRs and why you have like 20 or 30 on one property, and if it's, and what is the zoning and all that. It's just for my edification, Chair. The only other question I have is more of a statement. We're talking about the TAC, which is the Technical Advisory Group, and even the focus groups that you went out in the field to see. I was looking at where the locations were, and some of the locations were kind of interesting that, like, for example, one is by my backyard in Aiea, and we don't have pretty much no farming. So I was wondering, why didn't you have it in the district? Let's say in Waianae, in Haleiwa, I mean, those, the lands we're talking about now. So I just was wondering, why couldn't you have it out there?
Do you understand?
Oh, why were they not out in the farm?
Why were the community meetings not held in areas with high concentration of farmland?
Thank you, Chair.
Answer that. Contract.
City, were you going to respond to the comment from Commissioner Wong?
Well, personally, I'm not sure why the discussion ended up in those particular areas. I imagine it has something to do with how the contract was worded. We tried to do as many as the contract allowed in the community. For example, we did have some out in Haleiwa, some in Kapolei, but due to the limitations of the funding, we were not able to have a meeting in every neighborhood, for example.
Okay, that's all I need to know. Thank you, DPP, and thank you, Chair.
Okay, commissioners, are there further questions for the city at this time? If there are, that's fine. If not, we'll go on to the Office of Planning. Commissioner Chang.
I promise, this is my final question.
I
know, I do promise. Mr. Puna, as a practical matter, if the Land Use Commission determines the city did not comply with the process and remands this back to the city, what will you do?
Well, I hopefully, if you do remand it, that the commission will provide us very explicitly how we did not meet those standards, and how you think that we should proceed in order to meet those standards. But I think we would look to you to point out exactly how we have not done an adequate job, and then we would do what is required of us.
Okay, that's good, because I was wondering, as a practical matter, will you redo this process all over again?
I hope not, but I mean, if there's parts that would need to be redone because we haven't met the standards, then I think we would do that. But
okay.
I can't give a definite answer at this time.
All right, thank you.
I will have a brief follow-up to Ms. Apuna from that question from Commissioner Chang. Having sat on this commission now 6.5+ years, the hardest projects are the ones where members of the public still have basic questions about the issue in front of us, because whoever the proponent is, whether it's for a rezoning, a district boundary amendment, or some other action, they have not done their outreach. The easy ones are when the outreach has been done so well that people aren't here to learn for the first time about what's going on, but to support or oppose. And even when there is some opposition and some support, our job is we're able to concentrate on the most important things when there's not just sort of confusion over what the project is, what the impact is, and what the issues are. So I've heard what you've said is you'd like us to specify in what ways that you may or may not have reached the criteria under 205, but what else the opinion of this commission was, you might have technically met the requirements, but we would rather think that you as the local agency are better equipped to do a bit more outreach before coming back to us. would that not be within the realm of something this commission could do in order that we could have a well-supported and effective process when you next come to us? I remember a certain candidate saying it's about you.
Yeah, I mean, it's also just about the statute, you know, I mean, I hear you, I hear Commissioner Cabral and the other commissioners that aren't happy with the result necessarily. But I think it's largely the process that we followed, and I don't think we can be deemed for following the process and the result wasn't what you had expected or wanted.
If I may respectfully, you can follow the process by checking the boxes. And if one of your earlier comments was, well, consultation with the neighborhood boards is not technically required. And like, yeah, okay, so you followed the process, but nobody here would debate whether or not that would have been a good thing to do.
Sure. But as far as a statutory requirement, we need to just meet the statutory requirement. If the commission or if the statute required more, obviously we would have met that. I understand. Yeah, we could have done more. We did do more than what the statute had required. But I think our obligation here is to meet the requirements of the statute.
Yeah, may I add something, Chair? This is Raymond.
Please, go ahead.
Yeah, I see where this is all heading, but you know, the practical nature of doing this is very difficult based on the funding, the resources that we have. Let's say we were to start this process of notification again after if you were to send it back to us. We would need to have meetings with all the neighborhood boards affected with the limited staff we have and the funding we have. Then we'd have to do another mail out or multiple mail outs. And that takes resources. And the biggest problem is the amount of time this is all going to take. Because look how long it took us to go through this process and to get to you. Would we have to then go back through the entire thing, go through city council, come up to you again? The logistics would end up giving you similar kinds of errors like we have, you know, experienced in the past. The parcel gets subdivided, owners change, parcels are dropped, people move. So it won't be error-free. I mean, we can try to minimize it by reducing the amount of time we spend in redoing this notice or outreach again, but I don't know if the results would be much better than what we have now. You know, it's one thing to say we have all the technology to do it, but actually applying it is a whole new different story. It takes a lot of effort and it takes a lot of time.
I mean, respectfully, thank you for your response, and I appreciate it. You know, it's taking a lot of time out of my schedule, and I'm not paid to be here.
To add something to Chair, may I add?
Yes.
I understand that the people that testified yesterday, you know, they said they didn't get the notification. There was a lot of misunderstanding on what IAL would mean for them. But I don't necessarily think the basic questions on what this means was not conveyed to the general, you know, to the public, because out of all the folks that were notified, the 1,800 plus people, I don't know the exact number that testified, but that's still, you know, a small fraction of the larger number. And I think with community outreach experience, it tends to be folks that are opposed that are going to come in or that are confused. Well, those that understand what it means are not necessarily going to be submitting testimonies. So that's just my personal observation.
Thank you, Ms. Wong.
Chair Schroyer, I can add. I mean, if it would be helpful, I think we can work with the neighborhood commission and put out this information of what's happening currently, we can definitely do that. I know that the boards meet once a month. We can put that out and let them know the status of the IL, what it means, because, and basically do that if that would be helpful to the commission.
Thank you, Ms. Apuna. Commissioner Ohigashi, followed by Commissioner Cabral.
I'm going to just say, I think that this train of argument or statements would be much better reserved before we make the decision. And I have some things to say about why Maui County doesn't do it, because it's an unfunded mandate of the state. So,
okay, thank you, and I apologize, Commissioner, if
I think we should try to see if we get evidence.
Thank you. Commissioner Cabral.
Yeah, thank you very much, everyone. And I am clearly appalled at the process. But what I think that when we say maybe we need to, you should go back to the square one, I would go all the way back to selecting the properties. This idea that you throw a huge net over everything in the general vicinity of that may and probably has an A designation, some of which apparently, got it here on my notes, can have a dual designation that allows for ag and country or something. That's, I don't have that on my island, but so the fact that you include all these things, but Mr. Young indicated that based on data that's available to you, you can know what the rainfall is, you can know how much soil's on a property, you can know the incline and the things like that. That would be where to start. And I mean, I can appreciate that there's gonna be, I manage properties, I got it. People are gonna be pissed off because the neighbor has chemicals and then they don't want it, they're residential. But that's what you've already inherited. You cannot go back 50, 60, even more years before all this land started getting chopped up. All of this land is what we got to deal with now. The fact that it's not an ideal situation doesn't mean you can just suddenly, I mean, a lot of these properties were owned by families before statehood, before there was a zoning, before anybody cared what you did. So now to force them and then say there'll be one more level of what you'll be in violation of, I don't know if that's really fair to
Commissioner
this.
Cabral, did you have a question at this point?
No, I have a recommendation that if they're gonna look at this, they don't just go to neighborhood boards to say we checked off another thing, but look at the lands they select to see if they're really ag lands or not. That would be my start.
Thank you for your statement. Are there further questions for the city at this time? If not, bearing in mind the good advice of Commissioner Ohigashi, we should continue on the evidentiary portion of our docket. Are there further questions for the city at this time? If not, Ms. Kato. Let's continue with the Office of Planning's presentation.
Okay. Alison Kato, Deputy Attorney General for Office of Planning. Thank you, commissioners, for allowing us to present our comments here today.
Oh, you just jumped.
Mr. Chair, if I may, for everyone's we've just discovered that there's an island-wide power outage on Kauai, and which is why we do not have Commissioner Giovanni.
That is problematic.
Mr. Chair, we are still recording this. We can continue because we do have quorum. It may be at your discretion on whether or not you would like Commissioner Giovanni involved with decision-making. In that case, we could defer decision-making until a later date, but we can continue the hearing.
So if I may, with the forbearance of OP who had just planned to start, I'd like to assess the progress of our proceedings right now. I anticipate, I'm not suggesting this or urging any of my fellow commissioners, but I anticipate that there may be certain questions that will arise when we enter into deliberations on this matter, for which we will want to go into executive session to seek the advice of our counsel regarding our powers, duties, privileges, and immunities in regard to the designation of IAL and the process that's before us. There's a lot of people waiting in the room, and that's a lot of people to wait while we go into executive session. In addition, we have unfortunately lost Commissioner Axon as well, who would be helpful in our deliberations, as well as Commissioner Giovanni, who is now inadvertently, due to power matters not beside his, not within his control, no longer able to participate. Frankly, I'm concerned on whether or not we can get 5 votes in any particular direction, given just the tenor of the comments and questions from our fellow commissioners. So my inclination is to proceed with the presentation from the Office of Planning. But at the conclusion of any presentation from the Office of Planning and questions, we would not directly move to deliberations on this matter, but we would defer deliberations and until we next gather as a commission.
Chair, I agree on that, but I would also like to just say that because Commissioner Axon and Commissioner Giovanni didn't have a bite at the apple with OP, they're allowed to review the recording and then maybe have a bite at the apple with them. Ask questions, sorry.
Okay, so in that case, the recommendation would be that we would not actually close the evidentiary portion of this proceedings, but would leave it open for the narrow purpose of further questions for the Office of Planning from the 2 absent commissioners.
Yes, Chair, if that's possible.
Okay, Commissioner Chang, did you have something to say regarding this discussion on proceedings?
Yeah, I would just support your recommendation that we permit OP to proceed and then call a recess to permit the other commissioners to participate.
Okay, well, it would be, I think, just technically not a recess because it would be the end of our hearing for today. So we would adjourn and then it would come up at our next hearing. Thank you. Okay, so with that, thank you for your forbearance. Ms. Kato here on your first time before us. We appreciate it.
Thank you. Well, Ronnie Funikoshi from the Office of Planning is here, and he's going to present the Office of Planning's comments. And I did also want to mention that the Department of Agriculture has someone here, Earl Yamamoto, who would also like to present comments if possible.
Okay, so we should admit Mr. Yamamoto. Let me, if you want to raise your hand, Earl, I will let you in. Mr. Funikoshi, do you swear or affirm the testimony you're about to give us the truth?
Yes, yes, I do.
Thank you. And I'm admitting Mr. Yamamoto as a panelist as well. Okay, please proceed.
Okay, good afternoon, Chair and Commissioners. Rodney Funikoshi from the State Office of Planning. Okay, I'd like to present OP's comments on the matter before us today. An IL designation signifies the resource value of the land. Is the parcel capable of producing sustained high agricultural yields? Does it contribute to the state's economic base and local food security? Is the parcel needed to assure the long-term availability of agricultural lands? So an IL designation helps meet the state's constitutional mandate to protect the state's agricultural resource base. An IL designation discourages the fragmentation of high-quality agricultural lands and the conversion of these lands to non-agricultural uses. An IL designation seeks to maintain affordability of agricultural land. It does not require that the land currently be used for agriculture. The Office of Planning has been charged by the legislature with updating the state's 2050 sustainability plan for the decade of 2020 to 2030 and integrating sustainable development into land use planning. Sustainability means, in part, using Hawaii's limited resources sustainably in the present while preserving those resources for future generations. One of those limited resources is highly productive agricultural land. IL designation is a tool for protecting those lands for future generations who will be living with climate change and the need for a locally grown food supply as natural disasters threaten to isolate Hawaii from imported food. Oahu is especially vulnerable since almost 75% of Hawaii residents live on Oahu. Food grown on Oahu does not need to be transported by air or water in the event of a natural disaster that blocks access to our harbors and airports. OP has provided comments and recommendations on the process and maps for the city's IL submittal in our February 10, 2021 comments to the LUC. OP questioned the inclusion of state lands, small lots, and lands with steep slopes, which would constrain commercial farming. These issues underlie some of the concerns raised by public testifiers in yesterday's hearing. This is the second city submittal of its IAL recommendations. Note that 2.5 years ago, in August 2019, the City Council submitted its IAL resolution 18-233 CD1 FD1 and associated files. Land Use Commission staff, by its letter of October 16, 2019, to the City Council, stated that the city submittal did not meet the requirements for processing as set forth in HRR 15-15, subchapters 14 and 17. It was clear from the testimony yesterday that many people did receive notice that did not receive notice of the city IAL process. Could the city have done more public outreach? Possibly, but planning processes cannot ensure that all residents and landowners will participate. The Land Use Commission has a latitude under Chapter 205A to accept the IAL recommendations, in part to exclude or include parcels for IAL designation. OP and Department of Agriculture provided recommendations in their letters submitted in February as to what lands could be excluded. OP's position is that the city has met the applicable statutory and procedural requirements in developing its recommendations. The city's IL process included consultation with stakeholders, landowners, agencies, and agricultural interest groups, development of a methodology for identifying agricultural lands and IAL lands through a technical advisory committee of which OP was a member, a public information process, including notification to affected landowners. It is recommended that the Land Use Commission acknowledge the efforts of the city in moving forward with the county IAL designation process and determine whether the city has complied with the applicable statutory and procedural requirements in developing their IAL recommendations to meet the state's constitutional mandate. If you find that the city has met the statutory and regulatory requirements, LUC may then deliberate on whether the city's IAL recommendations serve to protect Oahu's capacity to increase its food security. Thank you. Okay, that concludes my testimony, and I'm available, as well as our counsel, both Ms. Kato and Mr. Yee, in the event there are any legal related questions as well.
Okay, Ms. Kato, did you want Mr. Yamamoto to present first or make Mr. Funikoshi available for questioning and then Mr. Yamamoto?
I think we can go into questioning at this point.
Okay, commissioners. Commissioner Wong.
Thank you, Chair. Good afternoon, Mr. Funikoshi. It's good to see you again. Just a question about that statement of the food sustainability. So in your opinion, this IAL process is for future, is that correct? Future generations?
Yes, it does help.
It helps, or is it's a planning tool to protect us for the future, to ensure that the state is sustainable in case of another COVID function where everyone's grabbing for food. Yeah, emergency.
Yes, it's one of the tools, planning tools available to help with food sustainability.
Okay, that's all I needed to know. Thank you.
Commissioners, further questions for Mr. Funikoshi? Seeing none at this time. Mr. Yamamoto, can you enable your audio and video? Hi, Earl.
Sure.
You have some comments to share?
Yes.
Do you swear or affirm the testimony you're about to give is the truth?
Yes, I do.
Okay, thanks. Please proceed.
My name is Earl Yamamoto, staff planner here at the Department of Agriculture. And as you can see from the video, I've been here for a few years. We did not develop or we did not develop separate testimony from what we submitted to the Land Use Commission back on February 9th, which is our letter to the Dan Denker. So my comments would be basically to summarize what we had submitted and what is contained in that February 9th letter. I will very quickly go over basically what we put down, and it's going to be in a format different from what the Office of Planning, Ronnie Funikoshi, has just presented, which is reflects upon what has transpired over earlier this morning and yesterday, throughout yesterday. So you have to excuse me for being, this is a little bit more distant. Our comments or more not dwelling in the details of process and procedure, but looking at it from the standpoint of the utility of the important agricultural lands law and moving our interest in having it move forward beyond what it has done so far with the participation of private landowners in the voluntary important agricultural lands designation. So in brief, the department supports the city and county of Honolulu's petition or submittal identifying IAL and recommends that the agricultural lands itemized in the petition be designated as important agricultural lands. We have reviewed the petition and find that it addresses to our satisfaction the evaluation criteria for state agency review as found in section 205-48. The deep economic damage wrought upon Hawaii by the pandemic upon many island businesses, including farm operations, makes the approval of the city's petition much more than just achieving the county identification of potential IAL as described in section 205-47. The existing farms, many of which lost 40 to 60% of their sales, and those landowners or others who may want to undertake agricultural production may have access to the 7 IAL incentives. The Department of, the Department of Agriculture believes the process utilized by the city leading to the development of the final maps was deliberate and thorough. We did participate in the Technical Advisory Committee for about 5 years. And during this period of time, the department kept in mind the underlying intent of the IAL Act is to support agricultural production and not to be another zoning layer. Specifically, Act 183 of the 2005 Session Laws of Hawaii Section 1 states that the intent of this act is not only to set policies for important agricultural lands and to identify important agricultural lands, but also to provide for the development of incentives for agricultural viability in Hawaii, particularly for agricultural enterprises that farm important agricultural lands and for landowners of important agricultural lands. These incentives would be designed to promote the retention of important agricultural lands for viable agricultural use over the long term. I'm going to skip over the city process to identify IAL. I believe we've had significant discussion on that. We did identify apparent anomalies, I guess, of which is of concern to the commission. We did note that about 38% of the tax parcels proposed for IAL designation along the leeward coast from Waianae Valley through Lu'u'ulele or less than 2 acres. Similarly, about 45% of the tax parcels proposed in the Waimanalo to Monowili area are also less than 2 acres. We chose 2 acres because that's widely understood as the minimum lot size in the city's least restrictive agricultural Ag 2 zone. Department staff didn't have the time to go over the remaining geographic areas to do a similar analysis. Nevertheless, department believes that the potential IAL areas described for the most part significant areas of potential IAL in accordance with section 205 42B that states the objective for the identification of IAL is to identify and plan for the maintenance of a strategic agricultural land resource base that can support a diversity of agricultural activities and opportunities. Let's see. With respect, I recall some questions yesterday brought up about state lands not being included. I'm not sure if I would need to bring that up, but just by definition, the land such as that under the management or title, I guess, of the Agribusiness Development Corporation are excluded. They are not considered public lands, I guess, pursuant to section 171-2. And the same exclusion applies for the Department of Hawaii and Homelands. That's for those lands all out in Waimanalo, the agricultural lands out in Waimanalo, the University of Hawaii, which has extensive agricultural lands in Waimanalo, and the West Oahu campus, Maukaside, Hawaii Housing Finance and Development Corporation, Waihole Valley, that Waihole Valley Agricultural Park. Let's see. As for the identification of public lands that are qualified to be important agricultural lands, yes, the Departments of Agriculture and Land and Natural Resources realize our statutory responsibility. It's been a while. It's been like 18 years in the making, and we're still working on it. The department firmly believes that the county process of identifying IAL as described in the submittal is separate and apart from the public land process that is described in section 205-44.5 and is not a valid reason to delay the county process from moving forward. I do have some explanatory things about why why we agree that the city's usage of a certain soil database was used instead of the Land Study Bureau, which is a much more familiar soil quality index that is commonly used, I guess, in proceedings before the Land Use Commission. And historically, the department has used the LSB, the Land Study Bureau overall productivity ratings, which range from A through E, from the best to the worst quality productivity potential. And we also use the land type, which is not found in any geographic information system database that I know of here in the state. And it's the land type that describes physical characteristics, specific crop productivity potential within the LSB's reports. The data layer found in the Office of Planning's Geographic Information System program maps only the overall productivity ratings and not the other data attributes that we have historically used in reviewing petitions for voluntary designation of important agricultural lands. While this is a technicality, I believe this is a very important thing to go over. And in summary, again, the department supports or finds the city's petition addresses to our satisfaction the evaluation criteria for state agency review as found in section 25-48. And we recommend that the agricultural lands itemized in the petition be designated as important agricultural lands. Thank you. I'll be available for any questions. That concludes my presentation.
Thank you very much, Mr. Yamamoto.
You're
Commissioner Ohigashi.
Mr. Yamamoto, is that your office you're in?
Yes.
You didn't have to tell us that you're a long-term employee. I can see from the desk. But anyway, when I was and this question probably would go to Rodney too, and I forgot to ask Rodney about it, is that you were part of the TAC.
Yes.
You're on the committee, and I asked this question about the last. Hi, Dan. He's waving. I asked this question the last time about from the city as to whether or not the TAC had approved the final recommendation to the most recent recommendation to the city council. Do you recall being at that meeting or approving this matter?
That when you say that final meeting, the meeting, the last meeting of the TAC, or yeah. Yes, I was.
When was that?
I'm sorry?
When was it?
I don't know. I'm going to have to go over my notes. That's such a long time ago.
Was it 2019?
Okay.
2018?
If you give me a few minutes, let's see if I do have that up on my.
Chair, since we're waiting, I just wanted to say that Commissioner Giovanni's back on.
Yes, we welcome Commissioner Giovanni back, and Commissioner Giovanni, we noted in your absence that we might conclude with the Office of Planning's presentation today, but defer deliberation to another date.
Okay, I'm sorry. I'm still looking. I'm getting there. I'm going to.
I can again offer to play the Jeopardy music.
Okay, please do. Yes. Yeah. The past University of Hawaii games, yeah, they put that on pretty quick. Okay, oh, no matches found. I cannot answer that question.
Was it before it was given to the city council that you
Yes, yes.
you went over the whole recommendation?
Yes, it was before the DPP submitted the final the package to the city council.
Was there any concerns raised by any of the participants at that time?
I don't recall any strong ones, but again, my memory is not that good. It's just about as my ability to add and subtract. It's kind of declined in my as I increase in age. I cannot recall any strong concerns about any matter at that time. Frankly, I think a lot of the members were kind of happy to see the process actually end up with a tangible result, namely the maps.
And was there a final vote on the whole thing, or was it just everybody agreed it should be?
I don't recall if there was a hand vote or anything formal like that.
Mr. Yamamoto, you did say that there were some areas, I think, that you have not done certain calculations on, and you have to excuse my memory on that. Could you explain to me what was that about?
That was with respect to what we had submitted back on February 9th to the Land Use Commission in our letter. We did go over, or I did go over the tax map key for those parcels found in the city council's resolution submittal to the Land Use Commission. I did go over the list of the tax map key parcels that were less than 2 acres. So I did it in these regions that contain that mix of ag, less than active ag production, namely on the Leeward Coast and in Waimanalo. So I did that, and the idea was to, because I, like everybody else, it stands out that there are a lot of parcels that it was very surprising to me that there were so many parcels that were less than 2 acres in size. I did not check to see if any of these less than 2 acre parcels were dedicated for property tax purposes to agriculture production, which would result in a decrease in the property tax burden of that particular landowner. So I did not look at it in that manner.
Is that a necessary or important factor that should be looked into prior to a final decision on this matter?
These small, less than 2 acre things.
Well, you mentioned that you didn't look whether or not they dedicated to these small 2 acre lots or dedicated to agriculture.
Yeah, dedicated. Yeah, what?
Is that an important fact that we need to consider before we make a final decision on this matter?
Well, it would add more information to the decision, whether or not it's required. All this process and procedure stuff is something that we obviously stayed away from, stayed apart from. But in terms of, in case you're wondering if these small agricultural parcels, in fact, can be used for agriculture, that would be give an indication.
So would it be, if we were to accept the city's recommendation and then move to a determination of whether or not to adopt it, modify it, reject it totally after hearing, would you be able to provide that information to the commission?
I would prefer that the city Department of Fiscal Services, Real Property Division, that function provide that information, because if not, I'd just be a third party. And accuracy accuracy kind of degrades when there's intermediaries between the source of the information and the giver, which is me, and then you being on the commission and the receiver.
So just to shortcut the answer, it says you could, but it would be better if we ask it from the city.
Directly, yes, that is correct.
I don't have any more questions.
It's 2:32. We've been going yet another hour. How many folks have questions for OP at this point? Nancy, you are deliberating whether you do or not. I can see. Anyone else? And I could go either way. I could, we talked about leaving this hearing open, the evidentiary portion open, or, widely or narrowly. I could go any way. I do think it is probably better, given the way the matters have proceeded before us today, that we try not to move to deliberation, but rather we do what evidentiary work we can do today and then conclude. Commissioner Chang.
Yeah, thank you, Mr. Chair. I'm not too sure. Many of these attendees have been sitting here for 2 days, and I would suspect they'd like to hear some of the discussion. So I'd like us to think about that. I realize that Commissioner Axon isn't here, but it would be very dissatisfying, I think, for these attendees if they don't hear some of our deliberation or discussion. That's just my thought.
I thank you for that comment. I personally, there's certain matters that have been raised, particularly around due process, that I want the benefit of discussing with counsel prior to entering into deliberation.
Chair?
Yes.
Just my own, I think that because Commissioner Giovanni wasn't here for the entire proceedings of OP, and I'm not sure about the rest of the cities, I think for him to deliberate properly, he should review the recordings of when he missed. And so I don't think, and give him the opportunity to, again, ask questions before starting deliberation.
Commissioner, thank you, Commissioner Wong. Commissioner Ohigashi.
I just was wondering where we're at. Are we gonna, you're deliberating whether or not we should keep the record open for the purposes of Mr. Giovanni and Commissioner Axon?
I'm assessing where we are in the proceedings, yes, and figuring out whether as a group we might decide, or at least give our sense for the chair to decide what we should do for the remainder of the day.
There's my preference is that if Mr. Giovanni agrees and Mr. Axon can't agree, but I would think that they would want the benefit of the whole record before making a decision, as well as an opportunity to ask questions if they have any of Mr. Funikoshi and Mr. Yamamoto. But that is just my.
I think procedurally, Commissioner Wong is corrected for Commissioner Giovanni to deliberate, and certainly for Commissioner Axon, they would have to review the tapes. So I don't think that I have tried to be very cognizant during these proceedings of the tremendous public interest and the long attention of the attendees, and certainly the desire by some of the attendees to, I would assume, see some kind of decision come out of our proceedings today that Commissioner Chang speaks to. On the other hand, I want to make sure that we do this in a procedurally clean way as possible. Commissioner Giovanni.
Yeah, thanks, Chair. Yeah, I would like to review what I missed, which was about 30 minutes. before we enter deliberations and maybe have the opportunity to ask questions of OP.
Yeah. And again, I also like, perhaps I'm the only commissioner who seeks the advice of counsel. But I would prefer to go into an executive session at some point on this matter prior to deliberation. And in that regard, I have a question for Ms. Chena. If the commissioners expressed a desire to go into executive session, would it be possible within the Sunshine Law to agendize such a session in a manner that would be like, for instance, the LUC will be convening at 9, but will be moving into an executive session upon convening, and will convene into public session, say at 10 o'clock, so that people who are wanting to attend and monitor our discussions would not have to sort of sit around staring at their computer screen waiting for us to come in. Do we have that flexibility to be respectful of all the people who are interested in this?
I think you do have that ability. I think though that when you first meet, you might want to just vote to go into executive session, and then you go into executive session.
But we could somehow indicate on the agenda that this might be
but you can say that we're gonna, we plan to ask to go into executive session, and then, from 9 to whatever, and that, we anticipate that the public portion of the meeting will reconvene at whatever time. I think that's perfectly legit.
Okay. Commissioner Giovanni.
I share your interest in an executive session.
Okay. Commissioner Cabral is thumbs up, enthusiastically double thumbs up. Commissioner Wong, do you have anything to opine on this matter before us?
Nothing, Chair. I agree with you on that matter, and thank you to our AG about her opinion.
Because again, we are trying to, while I have some significant concerns, as has been clear at the manner in which the impact, if any, of IL designation has been portrayed by outside forces, I do recognize that has raised considerable concern among property owners, and I want to make sure that we are respectful as possible within our constraints of their time and their tuning in. So, in that regard, sorry, very briefly, I know this is a little unorthodox, but would somebody from the LUC staff be able to share right now how one can join the mailing list for the LUC so they are sure to get the emailed notice of our meetings?
Thank you, Mr. Chair. I think Scott can best explain it.
Thank you, Mr. Derrickson.
Let me see if I can share screen.
Okay.
You're gonna get flooded. So on our website, which is luc.hawaii.gov.
Mm-hmm.
On the home page, on the right-hand side, you'll see this menu. People can click on it to sign up for agendas, notices. And they'll fill out a little form.
Okay.
And then you'll get a notice of the hearing probably about 5 or 6 days prior to the hearing. People are also have the ability to, on the homepage, they can check the event calendar. Which provides the tentative meeting dates. So if you check that often, you'll be able to see when hearings are scheduled. And as soon as an agenda is up and available, it should be posted.
Great. Thank you very much, Mr. Derrickson. I appreciate it. Okay. So back to our proceedings then. Are there any further questions at this time for the Office of Planning? If there are none, I will ask if there's any further business. And if there's not any further business, my intention is to adjourn our proceedings, noting that we will re-agendize this discussion, including an opportunity to ask questions of, for the commissioners to ask questions of, I will say, both the city and county as well as the Office of Planning and their witnesses. Is there any further business, Mr. Ordenk or anyone else?
Mr. Chair, I believe that concludes our business for the day.
Okay. So with gratitude to all of you for your tremendous efforts over the last 2 days, to the city and county, to the Office of Planning, and to the attendees. Thank you very much for your participation. I'm sorry we could not make it to a decision making on this matter today. However, we have made progress and we will agendize this matter for further action on a future agenda. With that, I adjourn today's meeting.